morning we have a full courtroom. I think that the students from VMI here are filling up the courtroom. We welcome you. I hope you hear something interesting. We'll have good counsel. We'll give you a good show. The first case we hear this morning is Rivas Nolasco versus Bondi, and Mr. Kim will hear from you first. Ms. Kim.
Good morning, Your Honor. Aju Kim for petitioners. May you please the court. The issue before this court is whether the board erred in finding no past persecution or well-founded fear of future persecution on account of membership in particular social groups. We argue that it has and ask this court to vacate its decision and remand this matter. The standard of review before this court is de novo for legal issues and substantial evidence for factual issues. When as here the BIA affirms the IJ's decision with an opinion of its own, this court reviews both decisions.
Can you start, first the clock's not going, second, can you start addressing our jurisdiction? And my concern, just to sort of be transparent, my concern here sort of puts two cases together, and I want you to help me understand why I should not do that or how I should do it in a different way. And so the first of those is Nasrallah, and that I take it to mean that there are distinct orders going on, that the order of removal or deportation is a distinct order from various forms of relief from that order, like think CAT, withholding, and maybe asylum. And so Nasrallah tells us that there are distinct orders that are at issue, and we don't merge the order of removal with other orders. So I take the Supreme Court to have told us that. And then I then combine that with our decision in Martinez, where we said there that a reinstated order of removal, I'm not sure why it matters that it was reinstated, but an order of removal becomes final, quote, when an alien chooses not to contest it. And so what I'm trying to understand is why putting those two together don't tell us that there was an order of removal that was entered by the IJ that's distinct from asylum or any other type of relief, and that the alien here chose not to contest it before the IJ and chose not to contest it to the BIA. And so that is to say that it was final when it was not contested, or I guess more technically under the dictionary section, it was final 30 days after he chose or she chose not to appeal it to the BIA. Help me understand what I'm missing there.
Your Honor, I believe it's pretty straightforward. Both parties agree that the BIA's decision on January 26, 2022 was the final order of removal, and that this petition for review was timely filed because it was within 30 days. It was filed on February 23rd of 2022.
No, I understand that, but that's not answering my question, right? So you acknowledge you can't agree that we have jurisdiction, right?
We do agree that.
No, but you cannot, right? The parties cannot agree to a court's jurisdiction.
I understand.
Okay, and so what I'm asking is, help me understand, not the conclusion, the dates. I understand the dates. What I'm trying to understand is, why wasn't the order of removal final at the point, at 30 days after the alien here chose not to appeal it to the BIA? It chose to appeal a different order, an asylum order, but it did not choose to appeal the order of removal. And so the dictionary definition section gives us two options, but one of which is 30 days after it is not appealed, or the time expires for appeal to have occurred.
Well, the IJ's order of removal did not satisfy the criteria for finality. As the Supreme Court explained in Bennett versus Speer, an agency action must mark the consummation of the agency decision-making process to be final. The removal order of the IJ was subject to review by the board, and petitioners exercised their statutory right to appeal. And Your Honor referenced Nasrallah versus Barr, and that is not applicable. It addressed a separate question concerning the reviewability of withholding only proceedings and did not alter the fundamental rule that an order of removal becomes final only after BIA review concludes.
Would it make any, I'm sorry, would it make any difference that there's jurisdiction where an order granting asylum, unlike withholding, prevents removal, and so therefore you would have jurisdiction? The fact that the asylum claim is appealed, does that make any difference as to jurisdiction?
No, I mean, our position is still consistent that the BIA's order was a final order of removal, and agency actions that are not tentative or interlocutory are not final. And the removal order was not.
Implied in your answer, actually, I had the same question that Judge Floyd had. Implied in your answer is that appealing a denial of asylum is a defense to an order of removal. Is that what you're arguing? In other words, you're seeking review, your appeal was from the order of removal based on a denial of asylum.
That is correct. And because the IJ's order was appealed, that was not.
Now, does that mean that that's in tension with the notion that you have separate orders for asylum and for removal?
Well, it's not the separate orders. They're all the same order that should be considered in their entirety.
Tell me why you think they're the same order. I mean, Nasrallah tells us they're not, and we read 1229A, and it treats the order of removal, or what it calls the order of deportation, separate from relief from that, right? And we have tons of cases that say you can't grant relief, like CAT or asylum, unless you have already entered an order of deportation, right? So 1229A, you have to first enter an order of deportation. Otherwise, CAT, withholding, asylum is irrelevant. So it has to begin with an order of removal. And that order, Nasrallah tells us, is separate from whatever relief you're seeking. Withholding, CAT, asylum. And it may well be, as Judge Floyd suggests, that asylum is different for some reason than withholding. But it's not that they're not separate orders. We know that the order of removal is separate from any relief from that under 1229A, C4, right? That's the relief piece. But 1229AA requires first an order of removal.
Well, we did have the order of removal, but again, it was appealed, and
Well, so tell me why it was appealed, because the alien here conceded removability and did not appeal it to the BIA.
because the IJ's order contained various legal errors that deserved attention of the BIA's
I'm sorry,
review.
the government's position is the IJ's order included various errors about removability? That's the government's position? If that's the government's position, why are we here?
I represent the petitioners.
Okay, I'm sorry, yep. So why, so help back me up then. So why, when you challenge the asylum ruling, does that count as a challenge to the removal order? Right? You do not challenge the removal order. You don't say I'm not removable. You don't say I shouldn't be removed, right, as an order of removal. You say I should get relief from that under 1229A C4, right? But those are separate orders.
Well, again, because it was appealed, the issues of
So
asylum.
tell me why you appealed the order of removal, which is a separate order from the order of asylum. Where do I look in the record to see that you challenged the order of removal on appeal to the BIA?
Well, the IJ, by denying asylum, sort of affirmed the order of removal, and the challenge before...
When you say sort of affirmed, what do you mean by that?
Well, by entering the denial of asylum order, the IJ, or the order of removal was entered, I guess, as an effective order. But then we are saying the asylum, or denying asylum, contained legal errors, and that's why we appealed.
But you agree you did not appeal the order of removal. There's an order of removal against your client today,
By-
correct? The IJ entered an order of removal. You did not challenge it to the BIA. You do not challenge it here. The order of removal. Now, you argue your client can't be removed because of asylum, but you have not argued to the IJ, to the BIA, or to us that there's not an order of removal against your client.
Your Honor, the asylum denial order goes hand in hand with the order of removal, and by
Oh, I
appeal.
thought the asylum order was a denial of an application. You apply for asylum, don't you? You file an application?
Yes,
And the IJ issued an order denying that.
yes. By denying it, the petitioners were deprived of a relief.
Denies a relief, right. But I guess your argument has to be, and it may be a complex question, but your question has to be somehow that the application for asylum is somehow a defense from removability.
I mean, again, both orders go hand in hand, and just by appealing the asylum denial order does not mean that we did not appeal the order of removability. They should be considered as hand in hand.
But do you agree that CAT relief is a defense to removability, but does not challenge the order of removal?
Yes, but I will not make a point on that because CAT claim is not before.
I understand, but I'm asking a question, right? So if we had a CAT claim, right, do you think appealing a CAT claim would necessarily call into question the order of removal?
Not necessarily.
Okay, and so so do you agree in that context that we'd have a jurisdictional problem? You think that because this is asylum, it's somehow different? Is that the argument you're making?
Yes.
Okay, and why is it that asylum? Because asylum is only entered after there's an order of removal, and it doesn't destroy the order of removal, right? It just provides alternative relief, right? The order of removal remains even after asylum is granted, correct? Can't be acted upon, but the order of removal remains.
I agree it can be reinstated, but still the asylum grant order is a final, meaning the order of removability cannot be enforced until after it's reinforced.
It can't be enforced, but it doesn't mean it doesn't exist, right? It doesn't destroy the order of removal. The order of removal remains. There's a separate order that limits the executive branch's authority to carry that out, but the order of removal remains.
That's correct. Unless the panel has any additional questions about the jurisdiction.
Why
Going
don't
in-
you, since we have a limited time, why don't we talk about the causation? The two incidents you complain about is one where the gang came in to to Rivas's house and sought refuge for an hour in the house. And the question is, the record seems to show they came in to hide from the police. And when the police risk was gone, they left her house. Now, you're saying that they came in not to seek a hiding place from the police, but rather to persecute her because she was a woman. That's your argument.
That's correct, Your Honor.
Where's the factual basis for that?
Well, there are ample factual bases, which the BIA disregarded. In fact, the petitioner, the lead petitioner, said that she was targeted because she was a single woman or single mother with no one, implying male figure, to protect her. That's in Joint Appendix 151. The gang members knew that she lived alone, just with her kids, with no father or father figure in the home, on Joint Appendix 153.
But the fact that they knew she lived alone, they may have picked her house as a place to hide, but is that persecution of her? They were hiding from the police for 1 hour, and then they left her unharmed.
Well, the gang members, they were armed, and they specifically...
I understand it. They were hiding from the police, though, right?
But they specifically said to the petitioner that she will be killed if she does not let them in. They may have been fleeing from the police, but still, she received death threats in the form...
She gave that threat to provide a hiding place. And
But-
she provided the hiding place without harm.
Well, physical harm is not a requirement of persecution.
No, it didn't, but it indicates causation. In other words, the nexus, the question is whether there's evidence that they acted in persecuting her based on the fact that she was a single woman.
Well, there's also another factual evidence that the BIA disregarded, which is the gang members, when they arrived in petitioner's home, they called her name out, meaning they intentionally came to her, even if one of the reasons they came to her was fleeing the police. And this was not considered in the BIA's consideration. And it was visible from the road, maybe, but that was cherry-picked by the BIA and IJ because the petitioners equally testified that she was the only single woman in the neighborhood. None of her neighbors were single women, and she was, known in the neighborhood to be living alone with her kids. So the nexus is pretty clear that even if the gang members were fleeing the police, they specifically sought this petitioner's home to
No,
hide
but
and threaten to
wouldn't
kill.
that be the easier hiding place? If there was a man in the house, he might say, "Get out." He might have had a gun and say, "Get out." The gang members knew it was a woman, and they're looking for a good hiding place. The cave was deeper and darker there.
Well, the petitioners argued in the brief that Salvadoran society at large values a woman less than Salvadoran men, and this means that women with men are valued more because of male presence, and which in turn means women without men are valued much less. And the gangs, if they were fleeing the police, they would have been seeking somewhere they could be easily hiding, meaning where there's only women without any male presence.
How about the incident involving the son, which of course didn't come up until after they got to the United States? She didn't even learn about it until after they got to the United States. How is that threat linked to the fact that she was a single woman? That was a classmate purportedly made a threat to her son. He actually encouraged the son to become a member of MS-13, and the son pushed back on that. But how is that linked in any way to the fact that she was a...
Well, the petitioner's testimony shows that the son was targeted because also it was known in the neighborhood that he was without a father, and without a male protection, he was more of a vulnerable target to, for the gang to recruit the son.
This is a boy classmate, right? And he's at school, and he's telling the son to become a member of MS-13, and the son says no. Now, and we don't even know if the other fellow was a gang member. It sounded to me like he was going to be a gang member, but I don't know what the threat was, number one, and number two, whether there's any evidence that that threat was made because his mother was a single mother.
Well, first of all, the petitioner's son's classmate said the gang had asked him to sell drugs, and even if the classmate was part of the gang or not, he still wanted to join the gang. And he specifically said that if the son refused to join, he, meaning the classmate, and the son would both be harmed or both be killed by the gang.
Okay,
And-
well, why don't we cover this on rebuttal? You have some rebuttal coming up.
Certainly, thank you.
All right, Mr. Robbins.
May it please the court. My name is Jonathan Robbins, and I'm here on behalf of the United States Attorney General. Good morning to everyone. I'd like to begin by addressing the jurisdictional question that the court asked the parties to address. My colleague is correct that the government does agree that there is jurisdiction. Now, I take Your Honor's point that we can't agree to jurisdiction, but we believe there's jurisdiction in this case for several reasons. First of all, the statute specifically provides a definition of when an order of removal becomes final that we think is applicable to this case. We also believe that the order is final under general administrative law finality principles. And then, of course, the third reason is sort of a general common sense argument, and if the court were to interpret this case as if the court were to interpret the statute or the law as not allowing for jurisdiction in this case, it would take a wrecking ball to the judicial review scheme that we currently operate. So let's start.
So why don't we start with the text, maybe? I understand all these other arguments, they're sort of fun, but why don't we actually figure out what Congress has told us to do?
Okay.
So help me understand, I guess Congress and the Supreme Court. Do you agree that Nasrallah teaches us that the order of removal itself is distinct from relief from the order of removal, which includes things like cat withholding and asylum?
Well, it does with respect to cat protection. It does say that in Nasrallah. But remember, let's start at the beginning with Nasrallah. The Supreme Court there found jurisdiction to review factual determinations. That case was involving a jurisdictional bar, the criminal alien bar at section 1252A2C. And the court, applying, among other things, a presumption of judicial review, ultimately found jurisdiction to review cat claims. So that's important to remember from Nasrallah.
Well, there's jurisdiction to review both of them. It was the standard of review in reviewing them, right? Could you review the factual predicates, not just the legal predicates? But I understand Nasrallah is a different case, but what I'm trying to understand is it sets out that the order of removal is distinct from relief, from orders on relief from removal. And just accept that that's true, because I think it's like undeniable. I know you can fight it later if you like to, but accept for a minute that the order of removal, which is 1229AA, right, that you have to enter an order of removal, is distinct from relief from that order of removal, including a variety of things. CAT is one example, but includes other things as well. And so if that's true, accept that for a minute for me. Tell me why, Martinez, when it tells us, admittedly in a different context, but it tells us that the order of removal in that case became final, quote, when the alien chooses not to contest it, why that same principle doesn't apply here, because the IJ entered an order of removal and entered an order on asylum. The alien chose not to contest either before the IJ or appeal the order of removal to the BIA.
Okay, well, there's sort of several things to answer there. Okay, Guzman-Chavez was dealing with a different type of removal proceeding, and it is important to distinguish. We are in what I would sort of...
I'm talking about Martinez, which is also the A5 proceeding.
Right, but that's an important distinction, because there...
Totally understand it's a factual distinction,
but
right?
It's more than just a factual distinction. It creates a problem with the statute. Okay, so the statute 1101A47B defines and sets forth when an order becomes final. And that definition hinges on an appeal to the board. So those other contexts become very problematic, because in expedited removal proceedings and in reinstatement proceedings, you don't have a right to appeal before the board. So the definition of finality becomes very difficult and complex, so complex that the Supreme Court is actually going to resolve that issue in the Riley case.
I get it.
Right? So we're in ordinary removal proceedings. We're not in that same type of proceeding, and that makes all the difference with respect to the statute, because there can be no doubt that the statute at 1101A47B applies to this scenario. We're in ordinary removal proceedings. And so that definition...
But help me understand why that is, right? Because we're accepting for a minute, you can fight it later, but that Nasrallah tells us the order of removal is distinct from orders on relief from removal.
Not quite, Your Honor. So Your Honor's alluded to this before, but this case involves asylum.
I understand that argument, and what I've asked you is to accept that premise for a minute.
Okay.
I understand that argument. I think it fails. We can talk about it, but I'm trying to ask the preliminary question.
Okay.
Right? So except for a minute that I believe, based on Nasrallah, that an order of removal is distinct from orders on relief, that they're just distinct. That is the simple line, right? And we have here an instance where an alien appealed the relief order, but chose not to challenge at the IJ or appeal to the BIA the order of removal.
Well,
And so in that scenario, it is appealed, maybe permissibly, maybe not, the one, but has not challenged the order of removal. And so instead of when the appeal was final, is instead 30 days after the choice not to appeal the order of removal that we have a problem.
Okay, so taking Your Honor's premise that they're separate orders
I
of
underst-
removal, you still have the zipper clause, which says that all
Okay.
questions of law and fact arising out of a removal
Good.
proceeding shall be consolidated into a
So
single
tell me
petition for
why
review.
tell me, it just help me understand, you're going exactly where I wanted you to go. Help me understand why that gets us there. Why, like, walk me through why B9 tells us that, the appeal of one order includes all of the IJ's orders.
Well, I mean, well, it's the specific language of the zipper clause says it shall be consolidated into a single petition for review. I mean, we know, there's no mystery as to what Congress was attempting to do here. They were trying to streamline everything into one proceeding before the courts of appeals. I mean, I know of no court that has taken a view that petitions for review would have to be filed after an IJ issues a removal order, but that whole order could still change, right? I know Your Honor is taking the view that they're separate and distinct orders, but that's just simply not true. If the board overturns the denial of asylum and grants asylum, that terminates the removal order. So the notion that that form of relief doesn't affect the removal order is just not correct.
Okay, so go back. I'll let you, give me the explanation of that, and then I want to turn it back over to my colleagues. So explain to me why granting asylum vacates the order of removal. Like, where am I looking to see that? I understand it prohibits, like, carrying out the order of removal, but you said it vacates the order of removal. Where am I looking for that?
I can't remember exactly where that is, but I'm certain that it vacates the removal order. I don't remember the source of authority for that, but you're right about withholding and CAT. Withholding and CAT determine where an individual can be removed. They
Do
can
you
be
have
removed to a third
suggestions?
country.
So, given where I've looked, it's like not obvious to me that it vacates, and so I understand your certainty is helpful. You're an expert in this area. But do you have any places that I should look if I'm trying to find authority for a proposition that, let's just say, seems less than obvious to me?
Again, the source of authority is escaping me, Your Honor, but I know it's the case. It's either through regulation or through board decisions, but once a grant of asylum has been
Presumably,
granted-
a regulation can't, like, vacate a statutorily demanded order, right? So, like, if your answer, it's what I thought you might say, if your answer is, oh, the regulations tell us that, maybe guess again. Do you have anywhere that's like, not the agency telling us what's happening?
If the court will permit, I'll supplement after argument in 28J the authority that we believe says that the asylum terminates the order of removal, but that is the way I've always understood it.
Okay, that'd be helpful. What it is about granting asylum that vacates an order of removal.
Okay.
That'd be helpful.
Now, again, this would create, if the court were to determine that the statute, which specifically defines the order of removal as becoming final, so even if you think they're separate and distinct orders, that order of removal, which is the term used in the statute, still becomes final under the exact language of the statute when the board affirms the immigration judge's order or
Or
the time
when
left.
30 days has passed, after you choose not to. And so here, the alien, in one view, I'm not even saying it's my view, but in one view, the alien had a choice to appeal the order of removal and did not. And so this is the second instance, right, where the 30 days kicks in rather than waiting on the board to act. So we're both looking at the same statute. I think you just are assuming that only one provision can apply, but that comes back, I think, is there anything other than the zipper clause that lets you think that the appeal of one order necessarily involves the appeal of both orders?
Well, I would say that I understand Your Honor's position, looking at Nasrallah and Guzman-Chavez in context, but there has been case law by this court subsequent to those decisions, for example, in the Salgado case, that would seem to establish precedent contrary to that position. So Salgado was a...
Not really, they're just drive-by, right? They're not addressing the question here, it doesn't seem like to me, right?
Well, Salgado was a case where the non-citizen also conceded removability, and the removal order became final on the date that the board upheld the immigration judge's decision denying requests for relief and removal, and the only remand was for voluntary departure.
There's no doubt that this issue, which has not been raised before, has not been addressed before. I totally acknowledge that, right? That the courts that have passed by this have not addressed it, right? But that doesn't help us, right? Drive-by jurisdictional rulings, like, don't get us very far. I totally take your point. The Supreme Court's done it, we've done it repeatedly. I acknowledge, like, I've been on panels that have done it, right? I totally understand that, but that doesn't answer the jurisdictional problem, right?
It doesn't, but again, this would be taking a wrecking ball to our judicial review scheme. It would be so contrary to what Congress was attempting to do. Every time that, I mean, I think it's very unlikely that the Supreme Court in Nasrallah and Guzman-Chavez, without saying so, said that, okay, we're going to bypass the statutory requirement that individuals exhaust their administrative remedies. We're going to bypass the zipper clause, and we're going to now require everybody to file petitions for review after an IJ's decision when it's not even clear that they'll need a petition for review at that point.
I'm not fighting that wouldn't make a lot of sense. I'm just asking whether, like, that's what the statute does. They're different questions, right? I'm not a czar designing what I think would be a good system, right? I'm trying to understand what the system is.
Right, but my point is you're interpreting this based on what the Supreme Court said in Nasrallah and Guzman-Chavez. And I find it very unlikely that every time the Supreme Court has been faced with a similar situation where they would interpret a statute that would make everything totally no longer make sense, they've refused to do it. They just did it as recently as Santos-Zachariah in the exhaustion context. They did it in famous cases like the Obamacare case, where they said, we're not going to interpret the statute that makes everything collapse upon itself. So the notion that the Supreme Court is espousing in Nasrallah and Guzman-Chavez, that we're all of a sudden ignoring 30 years of jurisprudence on how petitions are filed, doing this completely contrary to what we know that Congress intended. Respectfully, Your Honor, I think that's something of a stretch. I know that the court can't agree to jurisdiction, but I think the court would be putting itself out on a very lonely limb to find that petitions for review now have to be filed en masse after an immigration judge's order. That seems to be not a very plausible view of what the Supreme Court's doing. I take your Honor's point that there is some confusion, and that was actually a point. If you listen to a recent Supreme Court case in Boarfa, which was another immigration case, Justice Kavanaugh in that case alluded to Nasrallah, and I don't remember exactly what he said, but he said, I may have caused some confusion with that case. So I think reading Nasrallah in a way that totally wrecks our judicial review scheme is something we would implore the court not to do that here. And so, that's sort of the last argument, the common sense argument.
Nope.
But again,
I understand that one.
I think this can begin and end with the statutory language in 1101A47B. That specifically sets forth when an order becomes final. So even if you think that original order is separate and distinct, that order becomes final when the person either appeals to the board, and again, we're dealing with the same order. Those two may be distinct, but it's the same order in terms of...
Might be the same decision, but it's, I think, not the same order.
Well...
I mean, I think 1229A sets up a system where we have an order of removal that is distinct from an order on relief from that removal.
Right, but that's where this is distinct from those other streamlined proceedings. So streamlined proceedings, it's true there's an order of removal. For example,
It's
an order...
actually very much like the civil area where we have a judgment. The judgment is appealed and includes any order that was, even though the judgment doesn't address a particular order, any order that was preceded it in the litigation is appealable and reviewed. But I gather that's somewhat analogous to what you're arguing.
Yes. I mean, again, the statute says an order shall become final and hinges it on the board. right? And so those other, Guzman Chavez, which deals with a situation where you don't have an appeal for the board, in those proceedings, you have what's called withholding-only proceedings. That can happen months after the order is done. That's not the case in ordinary removal proceedings, where everything is done in the same process. And again, there is no mystery about what Congress was trying to do here. They wanted it to be done the way it's been done for the last 30 years, and I think it's very, well, I mean, you can never predict the future, but I think it's very unlikely the Supreme Court is going to espouse a scheme that creates total chaos in the judicial review area. I just don't think that's very plausible. I see I have a little time left. Unless the court has any further questions about jurisdiction, why don't I address the merits very briefly? As we've argued in our brief, there have been dispositive issues that have been waived, but even if those issues weren't waived, the record here amply supports the agency's conclusions regarding nexus, cognizability of social group, past persecution. Your honors have already alluded to it in the opening presentation with my colleague, but this is a very easy case to determine that the record supports the agency's conclusion regarding nexus. The petitioners were the unfortunate victims of opportunistic criminals, right? They were fleeing from the police. They needed a place to hide. Their home was, I guess, in the wrong place at the wrong time, so to speak. But there's no indication that the gang members in that situation were in any way motivated due to the petitioner's status as a single female or any family status. So the record there amply supports the agency's nexus conclusion, and nexus is dispositive of both asylum and withholding of removal. The petitioners are not challenging CAT. They didn't exhaust that before the board. So that's the easiest way to resolve the merits of the case. With respect to the cognizability of the social group, the agency, I think, correctly determined that single Salvadoran females isn't a cognizable group. The term single is amorphous. It's not clear what it means. Does it mean, not married? Does it mean somebody without a boyfriend? I mean, if you don't know who's in the group, it's not a particular social group, and so it fails on that grounds. The agency also pointed out that the group wasn't socially distinct. There's no indication that Guatemalan society views single females as a separate faction of society in any meaningful way. Yes.
Was there a finding by the IJ that the home invasion incident was past persecution? Was there a finding to that effect?
There was a finding that what happened to them in the home rose to the level of persecution. But in order to constitute persecution for refugee status, it has to be on account of a statutorily protected ground. But the IJ did say that the harm that they suffered in the home, being forced at gunpoint to sort of...
Well, would that finding be sufficient to trigger the rebuttable presumption of future persecution?
Not without a tie to a protected ground. And so the presumption is only met if the harm rises to the level of persecution and the harm is tied to a statutorily protected ground. So there's no presumption without that tie to the ground.
Let me see if we can agree on something else. If our president says death threats or persecution, then didn't Axel suffer persecution because he received death threats from the classmate?
Not quite, Your Honor. So what this court's precedent says is that a death threat can constitute persecution. But what the agency has a responsibility to do is to try to determine, is this some sort of systematic type of persecution, or is this just simply an isolated incident? And I think the agency did a pretty good job here explaining why they thought that this threat wasn't sufficient, even though a threat can be persecution, why it wasn't in this case. The agency talked about the fact that the petitioner, the threats lack credibility and immediacy and specificity. Again, as Your Honor already alluded to, the lead petitioner in this case didn't even know there was a threat until after she was in the United States.
Well, why wouldn't the answer to my last question be yes from both sides?
I'm not sure what you're asking.
My question was, if our president says death threats or persecution, then didn't Axel suffer persecution because he received death threats from the classmate?
Respectfully, Your Honor, the precedent doesn't say that death threats are persecution. It says that a death threat can be persecution. So this persecution is defined on a case-by-case basis. The agency has to look in every single case to determine what the particular acts were in the case and whether it's harm rising to the level of persecution. There are some cases where threats are so immediate or so specific or combined with other things that makes them so threatening that they can constitute persecution. But that's an assessment that has to be made on a case-by-case basis. So the precedent doesn't say that a death threat is automatically persecution. It couldn't say that. The board has a responsibility to determine persecution on a case-by-case basis. So the board here acknowledged that precedent that says that a death threat can be persecution. It specifically cited to that precedent in its decision. But then it explained why this particular threat wasn't sufficient to meet the high threshold that needs to be met in order for harm to be defined as persecution. I see that I'm in the red. If your honors have any more questions, I'm happy to answer.
Thank you.
Thank you very much for your time, your honors.
Ms. Kim?
To reply to the government's argument, no arguments had been waived by petitioners. If they were fairly presented in the opening brief, respondent had notice of all the petitioner's arguments and had an opportunity to respond. And simply, they have not waived any arguments whatsoever. And they were pretty much the same issues raised before the Board of Immigration Appeals. In this case, it's clear that petitioner received death threats on 2 occasions, March 2015 and September 2015. They both rise to the level of persecution. And in fact, the BIA does not deny that the September 2015 constituted past persecution. And also March 2015 also is past persecution because this court has long and repeatedly held that a death threat qualifies as persecution. There's just too many cases to cite here. And they were both...
Is your argument that anytime you receive a death threat, that is persecution for purposes of asylum?
Well, yes.
Always?
No.
Anytime?
I agree with my colleague that the court sort of has to consider the circumstances, but in these 2 incidents specifically, they do comprise a past persecution because they were concrete death threats. And these were on account of a protected ground. The petitioner was part of the family of her son, and also part of the single Salvadoran woman. And these are both cognizable groups. There's no dispute family is a cognizable group before this court's precedent. And single Salvadoran females is also a cognizable group. And in fact, in the consideration of
Have we ever held that Guatemalan women or Salvadorian women or whatever is a particular social group?
Well, the issue is single Salvadoran women, and I believe the court has not made an explicit finding on this, but we argue that it is a cognizable group.
We have an unpublished opinion, don't we, on that?
Yes, but on published
I understand. We don't rely on it for precedent, but we have looked at it.
That's correct. And also, because in the consideration of this PSG cognizability, the BIA did not give any consideration to the fact that she testified that she was part of the single Salvadoran females, and the board did not find whether this petitioner falls under this group. And because our argument is that she does, and the fact that she was persecuted as part of this group shows that this group is socially distinct. And also, the board disregarded
Well,
the fact...
that's a little circular. We've rejected that. And the fact that she was pursued doesn't make her part of that group. The group has to pre-exist the conduct and has to be the motivator for the conduct, the persecution, right?
Yes, but then still the board failed to consider the petitioner's testimony and her friend's testimony saying that she was targeted because she was a single woman without a husband. There's nowhere in the board's decision where the board gave consideration to this factual evidence, and petitioner consistently testified that the kids don't have a father or a father figure. And this is being perceived as unprotected. And also the petitioner's brief before the BIA also provided that petitioner's domestic status is a characteristic that petitioner should not be required to change. This also goes to the cognizability of this group.
Thank you.
Thank you.
We'll come down and greet counsel and then proceed on to the next case. After we come down and greet counsel, I'd ask you to approach the bench and greet Judge Floyd too. be seated. All right, the next case we'll hear is United States versus Milam. Ms. Dagger, we'll hear from you when you're ready.
Thank you. Excuse me. Thank you, Your Honors. Good morning. May it please the court. I'm Kelly Margolis Dagger, counsel for the defendant appellant David Craig Milam. This appeal arises from the government's failure to produce a search warrant that was the basis to search Mr. Milam's home. The search of Mr. Milam's home yielded critical evidence, the most substantial source of evidence in this prosecution, 3 prosecutions, 2 that are at issue in Mr. Milam's motion to withdraw his guilty pleas. Those prosecutions are for drugs and firearm-related conduct. The government produced only every other page of the search warrant and the supporting affidavit. The resulting document, and that document's in the joint appendix starting at page 116, it makes no sense. The numbered paragraphs aren't consecutive, and the narrative is obviously incomplete. It skips. Anyone, lawyer or non-lawyer, who reads that document can tell that it's incomplete. But what happened in this case is that no one read it. The government apparently didn't read it when it produced the search warrant and affidavit.
Could a defendant plead guilty without receiving discovery in a case?
A defendant could plead guilty without receiving discovery. And
Is that ever done?
It is certainly done, especially in the case of a defendant who agrees to plead guilty to an information.
And where's the evidence in this case that this affidavit was at all important to the defendant's decision?
So Mr. Milam, upon discovering, approximately 3 years after the affidavit and the warrant were first produced, Mr. Milam had new counsel. His new counsel immediately noticed that the warrant and affidavit were incomplete, and he asked for it.
We know all that. We know the affidavit, somehow the copying only copied every other page. But my question is, what evidence do we have that Mr. Milam relied at all on affidavit or the search or in order to plead guilty, and whether he would have pleaded guilty anyway?
Your Honor.
It looked to me from the record that he was very anxious to plead guilty, more anxious than we've ever seen in a record. Isn't that what the evidence shows?
Your Honor, the defense counsel at the time did testify at the hearing on the motion to withdraw the guilty pleas that Mr. Milam was anxious to plead guilty.
Not only that, she went over various defenses and ideas, and he didn't want to hear them. She said she'd never seen anything like it. He was just anxious to plead guilty, and what you take from the record is what he was trying to do is to cabin his losses, cabin his responsibility to the firearm charge, and avoid other exposure. Isn't that really the conclusion you reach from those facts?
That's what defense counsel's testimony was. Now, I'll note the court below said it wasn't relying on defense counsel's testimony, and I think there's an important reason not to rely on that testimony. The defense lawyer did testify that she attempted to advise Mr. Milam about suppression issues, various defenses, and as Your Honor, Judge Niemeyer pointed out, she also testified that he was insistent on pleading guilty and doing that quickly because he thought he might be able to avoid worse things to come.
Well, all that being true, what are the deficiencies in the full search warrant upon which you'd file a motion to suppress? I mean, is there anything in there that would have helped your client?
Yes, Your Honor, thank you.
Well, what would that be?
So there are 2 things. The first one is really an issue of the lack of nexus between the suspected criminal activity involving drugs and the location to be searched, which is Mr. Milam's home. The second thing is, and this is sort of a sub-issue, there's a potential Franks issue with one of the statements, at least one of the statements in the search warrant affidavit. So the search warrant affidavit essentially says, the affiant says, first of all, I know David Milam to be an Aryan Kings gang leader, and I know the Aryan Kings to be a gang that is known for drug trafficking and violent conduct. There's no indication in the warrant affidavit of how the affiant came by that information. Did it come from a cooperator?
We know that's true, right? I mean, we know, in fact, he is a member of that gang, right? We know those facts to be true.
We know
Based on
those-
his guilty plea.
We know that, based on his guilty plea, of course, the guilty plea did not include as an element of any of the charges participation in a gang. This is an RICO case. He did plead guilty to drug and firearm crimes. And there's
Based on
certainly
the
evidence.
I'm not asking you to concede it, right? I understand he's your client. But like, we know those things to be true. Just accept for a minute that they are true. How could that be a Franks problem?
The Franks issue, and I'm sorry, Your Honor, I haven't gotten to the Franks issue yet. So let me skip to the end and say, toward the end of the search warrant affidavit, there's a comment from the affiant about a search of the car that Mr. Milam was driving and finding a bag with, quote, a large amount of cash, marijuana, and packaging material. And there's no punctuation in that part of the warrant affidavit, but that what I understand to be a large amount of cash, marijuana, and packaging material is a large amount of cash. It's 2 grams of marijuana. It's a user amount of marijuana. And I think that's a critical difference here.
How much cash? $4,500?
$14,000.
$14,000. And packaging, how much packaging?
There's no indication of how much packaging material there is.
But there's no dispute that there was packaging.
That's
shown in the return, right?
the record below does not clearly show what the discovery was on the
Well,
packaging.
The only point I'm getting at here is Franks is a very serious charge. It basically says that an officer deliberately falsified an affidavit or was so reckless that it amounted to deliberate conduct. And that if you take out the Franks material, was there still probable cause? And it seems to me both areas are not even close in this case. I mean, there's just no evidence that this officer was acting as a rogue officer.
There is no evidence of that because there was no suppression hearing and there was no opportunity to even attempt to
Why are
explore
you raising
a
it if
Franks
there's no
issue.
evidence? I mean, you can't just throw it out there. You got to have some, you're arguing that because there's a potential Franks hearing, it was meaningful that this affidavit wasn't complete. But you can't make that argument unless you got some evidence. You can't say, oh, I would have looked for that.
Well, my focus here, Your Honor, is on one of the Moore factors, that the fourth Moore factor, and that Mr. Milam was denied the close assistance of competent counsel at the time he entered his pleas.
Yeah, but counsel went through in detail about how she worked with him. She was a professional. She was an experienced professional. And she said, never seen anything like it. He didn't want to go over those things. He just wanted to plead guilty. And he did plead guilty, and his guilty plea was accepted. And now you're saying that the affidavit, absent portions of the affidavit, had his counsel received those pages, he wouldn't have pled guilty. But we don't have any evidence. And then you say, had we had those pages, we could have done a Franks hearing. There's no evidence of that. I mean, it's, you know, you can only go so far in this, in these suppositions where you speculate. There's got to be some evidence to suggest he would not have pled guilty had the affidavit been complete.
And to be clear, Your Honor, Mr. Milam's argument is that the district court committed error in denying his motions to withdraw, his motion to withdraw his guilty pleas. And he did say, in support of those motions, that it's not just if he had had the missing pages of the affidavit, but if he had had the advice of a lawyer who had looked at the affidavit, then he would have made a different decision. He would have appraised the prosecution's case differently and decided to plead not guilty.
Can
And
I
there's
ask a
gonna-
slightly
Yes, Your
different question, back to your Frank's argument? What's the best authority for the suggestion that this type of Frank's issue that you've identified would be entitled to a hearing? I mean, we have a pretty high bar for saying, you don't get to just say that I've managed to read this like grammatical sentence in a way that might be mildly misleading, right? We set a pretty high bar for a Frank's hearing. Why do you think that if this was what you were pointing to, that you would have been entitled, your client would have been entitled to a Frank's hearing at all to inquire about it? I mean, it seems to fall well short of what we've said the evidentiary showing is required to even get a hearing.
Your Honor, that one detail about the discrepancy in what the search warrant affidavit says and then the amount of marijuana is the only thing that's of record that I could tell this court that I would say that could point in the direction of a Frank's hearing. But again, the issue here, we're dealing with an undeveloped record necessarily because there was no suppression hearing, there was no exploration of whether there was a basis for a Frank's hearing, and there's an important reason that the district court did not rely on defense counsel's testimony about having purportedly reviewed all this stuff with her client. And that's because she couldn't have done that. Anyone, even a non-lawyer who read the incomplete search warrant and incomplete affidavit would have known that there were pages missing. And so although the counsel did testify that she believed she'd reviewed everything carefully with the defendant and he had said, no, 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 I'm not interested, that can't be the case. She couldn't have done that, or she would have raised her hand and said, wait a minute, this is not the complete search warrant affidavit. Is there a basis for a suppression motion? Let me ask the Assistant United States Attorney for the full document and then assess that. And in this type of case, where there is such a wealth of...
So it's in effect, so your view is it's effectively, you would have us adopt the rule that unless and until a lawyer has reviewed all discovery, it's ineffective assistance to permit that defendant to plead guilty.
I would not, Your Honor. And I act as district court appointed counsel myself in a great number of cases, and I have cases that have hundreds of thousands of documents.
Yep.
But in this case, this is a case where we're dealing with drug and firearm charges that arise from, and I can't say they arise exclusively from, but there is at least a wealth of incriminating evidence, physical evidence, that arises from this search warrant. And so although it may not be ineffective assistance of counsel to fail to review the 30 hours of poll camera footage, I do think in this situation that yes, it's ineffective assistance of counsel not to review what is likely the only valid defense in a case like this one, where the client has been caught with the guns and drugs in his home. I mean, it's essentially, it's not maybe quite as bad as the case
So
where
when
it's
a
on
client
video.
comes to you and says, I need to plead guilty because they're gonna find that I've got a whole freezer full of bodies in my house, and so I wanna go ahead and get them, like, distracted by something else, your answer is that a lawyer has to say, nope, can't do that, right? First, don't tell me about the bodies in the freezer, but second, I'm gonna need to go do some research on this motion to suppress, despite your desire to enter a plea at the arraignment.
I can't say yes to that,
Right.
Your Honor, and of course, you know, that's an extreme case. Defense counsel didn't elaborate on, in fact, she said at the hearing below, she wasn't sure exactly what it was that Mr. Milam was concerned about. I don't know what he was concerned about. I agree that these situations are very fact-specific. There isn't and should not be some kind of bright-line rule that defense counsel has to do this in every situation. But we do know here there wasn't a strategic decision after thoughtful discussion not to pursue a suppression motion.
Wait, why is that? So why wasn't it a strategic decision after, maybe you think it's not thoughtful, I don't know this lawyer, I'm not trying to impugn them in any way, but whether it's thoughtful or not, like, there was a discussion, right? He said, I need to plead guilty because of the freezer, or effectively the freezer, and you know, the lawyer says, listen, I tried to go over the stuff with him, but he said he needs to do it now. Like, that seems like a purely strategic judgment to say, okay, I'll let you go ahead and plead guilty, rather than spending, you know, the next month researching a motion to suppress, which you said you don't want to file.
So I think there were about a month passed between the time that the incomplete warrant and incomplete affidavit were produced and the time of entry of the guilty plea. And in that time, some discussion occurred. The district court did not accept that testimony. The district court didn't discredit it, but said it wouldn't rely on that testimony. And Mr. Milam's contention is that review could not have occurred because if his lawyer had so much as reviewed the affidavit, she would have said, where's the rest of it? Whether she was going to file a suppression motion or not, she would have said, where's the rest of it?
The premise there is that when I skim through discovery and I see affidavit, that like if I don't stop and notice the numbers are off, that like that's like, we can't believe that a lawyer would do that?
In a
I mean,
sen-
you've reviewed enough discovery, like, can you really say with a straight face that like, it would be impossible for someone to have flipped through this and not noticed that the affidavit was missing every other page?
So it would not be impossible for someone to flip through it and not notice, but it would be impossible for someone to actually read the affidavit and not notice.
And your view is that absent sufficiently careful reading of every page, they were ineffective?
And I see I'm over time. Can I have just a minute
please.
to address that question? Thank you. Absent sufficiently careful reading of the search warrant affidavit that gave rise to the search that yielded most of the really significant incriminating evidence, it's ineffective assistance in this case. Thank you, Your Honor.
Thank you. Yes, and rebuttal. All right, Ms. Brown?
Good morning. Lucy Brown for the United States, and may it please the court. We apologize for the scanning error in this case, but the court should affirm because the defendant has not met his burden on appeal. Guilty pleas are strongly presumed to be final and binding. The defendant must prove to you that the district court abused its discretion in denying his motion to withdraw. There are 6 factors to consider. He argues only 2, and he prevails on none. First, to that knowing and voluntariness, there's sort of the rule of how you get a knowing and voluntariness factor on your side as a defendant, and then a small exception. The rule is you have a deficient Rule 11 proceeding. That's the heartland of this inquiry, and the defendant has never even alleged that, nor could he. The transcript is fulsome. The Rule 11 colloquy was thorough.
Well, I guess the argument goes something like this, is that in exercising my privilege to plead guilty, I did so voluntarily, but I did so following the advice of counsel, and I later discovered I received inadequate support of counsel. Had I had the correct support, I would not have made that decision. So I think it goes not to the voluntariness before the court, but to the voluntariness and even engaging in the plea because of the advice of counsel.
And I understand that to be 2 separate factors that the defendant has brought, the only 2 of the 6 that he has brought. The first is a separate knowing and voluntariness analysis, and I don't think that one hinges entirely on counsel. Counsel is its own factor, which I'll certainly address and be happy to. The knowing and voluntariness, I think, is where she put this notion of perhaps a Frank's hearing. I want to clear that up just right out of the gate. The page that counsel is referring to, it's on JA 121. It was in the original disclosure. So that actually had nothing to do with the delayed disclosure. So I don't think that's properly even in that knowing and voluntariness analysis. The knowing and voluntary is, did you have a thorough Rule 11 where you've completely advised, where you counseled there? Did you have the court tell you the risk you're taking? Did you make this decision knowing and voluntarily? There is a tiny sliver of an exception for the most egregious of conduct, which I've never understood the defendant to be alleging below or here. So he doesn't plead the rule there, he doesn't plead the exception. He tries instead to bring this sort of, well, I was supposed to have this, and certainly, that was our mistake. He should have had all the pages of the agreement. But that doesn't make this a knowing and voluntariness claim. The counsel question is a separate prong. And to have that, the defendant has to show.
Did the defendant file a motion for discovery here?
I believe he requested discovery in the original firearm case, not in the drug case, as that was pursuant to criminal information.
You know, this mistake is not going to make any difference in my mind, the outcome of this case, but this is the Eastern District of North Carolina. Can you tell me how this happened?
Your Honor, I think this was a clerical mistake. It was an administrative mistake. My understanding is this document came in from law enforcement double-sided, And it was as simple, as we've said below, as a scanning error. And we regret that mistake. We should have caught it. I think it was that simple. And I hope Your Honor has had an opportunity to read our latest 28J letter that references our petition for rehearing in another case where we lay out the measures that we have taken in recent years. This mistake occurred almost 6 years ago.
I understand, and I precipitated that, and that's why I'm asking again. This is not isolated.
We take these admonishment from the court incredibly seriously, and I hope that chart in the petition for rehearing shows the court how seriously we take these mistakes. And I understand the court's concern. I understand that we have been admonished by this court before. We are one of the largest districts in this circuit, and we do a lot of cases as a result. And we regret the 3 that have been acknowledged in that letter. We regret any instance where this arises, but we do hope the court sees that we take these obligations seriously, and we've taken measures seriously to try and eliminate those. At bottom, this was a clerical error, and we regret it. But in this case, it does not afford relief to the defendant. As to the counsel component of the question that Your Honor, Judge Niemeyer was asking about, the defendant hasn't even alleged what he would have to get relief under that. He focuses on performance, and I understand that's a strategic decision by appellate counsel, but it's not enough, even if he shows deficient performance, because he also has to show that he was prejudiced by that performance. He has to show that he would have gone to trial, and under this court's recent precedent in Mayberry from this past January, he has to show why he would have gone to trial. He has to get specific. He can't just leave this court guessing, and he doesn't provide that in this case. He does this sort of circular analysis saying, well, I moved to withdraw, so I must have wanted a trial. But that can't be enough, or else that prong of the ineffective assistance factor would be meaningless. That can't be enough, and he hasn't even tried to plead the facts that would show that in this case. There's been a lot of discussion about the performance. I do want to reiterate, the magistrate judge below didn't decide it, the district judge didn't decide it. We haven't argued it here because we don't have to prevail on this factor. But I do think page 369 does speak to what the defense attorney did. I think it's pretty similar to what Judge Richardson was suggesting. It says that she went through page by page. I think that's important because I don't think she sat down and read everything as a total document. I think she went page by page analyzing what was on each page and making notes. And the page that was included in discovery, you can imagine someone flipping through, here's a search warrant, where's the part with probable cause? Okay, a car left this house, driven by defendant, ran a stop sign, had heroin in the car, had $14,000, had a large amount of cash is what it says, a large amount of cash in the car, had marijuana, had packaging material. I think the sentence is unfortunately a comma mistake that defense counsel was referring to. I used to teach high school English. Commas can be very important. I think that is the problem here. This was.
Well, I don't know if it's a problem if it was produced.
Well, certainly it was produced, Your Honor. I think that's what opposing counsel is raising as the issue. I think commas would have solved that concern. I agree with Your Honor. It's not a problem. Thank you. I think that would establish that it was a large amount of cash, comma, marijuana, comma, and packaging materials. If the court is even close on these decisions, I don't think the defendant has met his burden. He's argued only 2 out of the 6. He hasn't alleged the others that include things like his legal innocence. And I think the government has shown why he doesn't prevail on any of them, including specifically the 2 that he has argued. I'm happy to talk about acceptance of responsibility or sentencing if the court has any questions. Otherwise,
Do you know what, he includes as a signature block in one of these white supremacist letter, 88 DC. I know what 88 stands for. Does the record tell us what DC stands for?
my understanding is that's for David Craig, his first and middle names, that's what he went by. And yes, as Your Honor referenced in the hearing in the district court, it indicated 88 stands as HH Heil Hitler for the 8th letter of the alphabet. But I think DC is David Craig, his first and middle initial. At bottom, this is a defendant who pled guilty twice to fulsome Rule 11 colloquies with counsel to crimes he committed. He then made decisions in custody with drugs and assault that stood to undermine the benefit of those plea agreements. And when he learned of the government's clerical error, which we regret, he decided to see what it could do for him. That's not what a motion to withdraw is designed for, and we would ask that the court affirm.
All right, thank you. Ms. Dagger?
Thank you, Your Honors. We agree that at the time Mr. Milam pleaded guilty, he did have the page, or his counsel had the page of the search warrant affidavit that included the comment without the commas about the large amount of cash, marijuana, et cetera. To be clear, Mr. Milam's point, though, about that page is that his counsel hadn't read it. His counsel hadn't reviewed the search warrant and hadn't reviewed the search warrant affidavit when he pleaded guilty, and that's why he didn't plead guilty with an understanding of what defenses he might have to this otherwise very compelling, incriminating evidence that the search of his home had yielded. On the prejudice prong, Mr. Milam's argument is actually quite different from the argument that the appellant made in Mayberry and that didn't succeed. So in Mayberry, there was a motion to suppress that was filed. One of the arguments that the appellant in Mayberry made in support of his motion to withdraw his guilty plea is that there were certain specific items of evidence that he didn't have that he should have had. And he didn't say why he needed that evidence. He didn't say anything about it. Mr. Milam's case is quite different. What Mr. Milam is saying at its core here is that his lawyer didn't review the evidence that she did have. She didn't review this important piece of evidence and didn't determine that it was missing. And if she had done that, that he would have made a different decision about whether to plead guilty or whether to go to trial. And it's not the case that I can stand up here and say—
But you agree there would have to be like a because at the end of that sentence, right? Like there has to be some reason, you know, I would have gone to trial because a motion to suppress was likely or plausible or something. It can't just be, I would have done it because of information, right? There has to be a because. And so, you agree with that part?
I agree, Your Honor,
Okay.
yes.
And so, if we were to say, and I understand this is not your argument, if we were to say that the issue you've raised on page 121 is in no sense a Frank's problem, I understand you disagree with that, but if that was true, do you agree the case goes away then? That you lose because on this particular argument?
No, Your Honor, it doesn't rest necessarily on the Franks issue. There's also the broader issue that Mr. Milam would contend that the warrant affidavit as a whole, with or without a Franks issue, was insufficient to provide a nexus to the location to be searched.
Okay, and if again, I'm just trying to understand the framework. If hypothetically we thought that was wrong, that either taking the pages by themselves or as a whole, there's more than an adequate nexus. So in other words, if we reject those two substantive arguments, the because language, then the claim fails.
I'm still going to tweak that a little bit, and if I could say it back
Yeah.
to Your Honor this way, I don't think Mr. Milam necessarily has to show this court that he would have won a suppression motion. So the district court said—
Yeah, that's why I said it's likely. Like there has to be some likelihood, right?
That's
Like,
right. So I don't
it's
think—
not laughably bad, which maybe these fall into the laughably bad bucket. But I just was trying to say, like, if we reject those as likely possibilities, then it fails.
I think that's right, Your Honor. I don't think Mr. Milam has to show that he would prevail on a suppression motion. I do think that if the court were to conclude, for example, that a suppression motion would have been frivolous—
What if he thought he could, I thought the question's a little beyond that. I thought even if he thought he could succeed and had a very good suppression motion, he could still plead guilty. I mean, your argument basically is that the counsel wasn't well enough informed, not whether there was a Franks motion, and because the counsel could have pled guilty without any discovery. You agreed with that? Or the counsel could have had full discovery and not reviewed it yet and pled guilty. I mean, the facts is an interaction between the client and the lawyer, and why the client chooses to do it. The client could say, I know I'm guilty. I want to plead guilty. I don't want to get a trial. I don't want to put my family through it. And I've got some other matters that I don't want uncovered. I don't care what you got in your file. Now, that's all legitimate. So the question is, we're asking here is, he pled guilty, and he pled guilty with a charge. I mean, he really came in and according to his counsel, he wanted to plead guilty from the get-go. And the question now is, he says, oh, because of this affidavit that misses every other page, I wouldn't have pled guilty. And he does that, of course, later after somebody else comes in and finds that affidavit. I think we need to not lose the question before us, which is, would he have pled guilty anyway based on this record? He has to demonstrate he would not have had he had full disclosure.
And I see that my time has expired.
No,
May I
please answer
respond?
that. Sure.
Thank you, Your Honor. So I think that the question isn't just, would he have pleaded guilty if he had these additional pages? It's, if he had had a lawyer who was competent and diligent and had read the search warrant, not every page of discovery,
Well,
but
those
this
are three
critical
different
search
things.
warrant.
So a lawyer probably was competent and diligent.
And-
The question is, what stage of the proceeding were we? I mean, the lawyer could have thumbed through it quickly and seen every other page and saw things on those pages that were sufficient. I mean, that evidence is pretty damning, that in his car that had left the home, they found $14,000, well, a large sum of money and packaging and drugs, and that he'd gone through the traffic violation and so forth. And that, well, his second car came out of the same place too. But, well, I think we understand your point, and I think you understand my concern.
Thank you, Your Honor.
Yeah, all right. Do you need you want a break?
No, I'm good.
Are you really?
I'm good.
Are you okay? All right, we're going to come down and greet counsel again. I'd ask you, after we come down, if you'd join Judge Floyd. All right, next case we're going to hear this morning is United States versus Breland. And Mr. Warren, we'll hear from you first.
Good morning, Your Honors, and may it please the court. My name is John Warren, and I am appointed counsel for Appellant Bernard Breland. This case arises out of a two-day jury trial on a one-count indictment charging being a felon in possession of ammunition. We've raised 4 issues in the brief. I'm going to focus my argument on the second and third, which relate to authenticity and lay opinion. Evidence, before I get into that, I did want to flag for the court, I filed a Rule 28J letter late last night in shepherdizing some of the cases cited in the fourth issue, which was the sentencing issue. There were 2 cases primarily, both out-of-circuit cases. One was United States versus Jordan, which talks about the Ninth Circuit's application of the clear and convincing evidence standard in sentencing enhancements and cross-references. Subsequent to the filing of this brief, the Ninth Circuit has changed that law and overruled that. And additionally, United States versus Brooks, which is a 10th Circuit case that was cited for the same issue, different sub-issue related to the application of the attempted murder cross-reference. That was subsequently remanded to the district court. The appellant was resentenced using the same cross-reference, and the 10th Circuit just affirmed that. Both subsequent authorities are frankly quite harmful to the fourth issue, but I wanted to make sure to notify the court about that. Turning first to the lay opinion evidence, here during trial, the district court allowed 2 lay witnesses, both law enforcement officers, to testify about the identification of the individual on the surveillance video. This is a shooting at an apartment complex. There's a large gathering outside, and the shooting is captured on surveillance footage, which we submitted in the joint appendix. The video footage of the shooting itself is not very high quality. The government's case essentially rested on linking that video footage, which shows someone shooting in a distinctive jacket, with other still images from different surveillance footage in the apartment complex. The first, and I think the analysis on these 2 witnesses is a little bit different. The first was Investigator McIntyre. He is actually a law enforcement officer on the gang task force, and his involvement in the case arises out of, after the shooting, the government sends out a picture from the surveillance video and asks law enforcement, does anyone recognize this person? Investigator McIntyre identifies my client as the individual on the video footage, and the government sought to introduce that identification at trial. Did not witness the shooting, had no personal knowledge of the shooting.
That one, you don't need to spend too much time on that one. It seems to me that's straightforward. He recognized that person, Breland, from an earlier thing, said so. You could cross-examine him, but I just find it very difficult to, your challenge on that one. I would spend more time, your time more on the second one if you want to focus on this. This is just my own personal.
Yes, right, and I certainly agree that the argument as to Investigator Fortner, the case agent, is much stronger. So let me jump to that. The government introduced evidence from the case agent. So this is the person from this is a local investigated case from the City of Columbia Police Department. And Investigator Fortner's first experience with my client, did not know him from his law enforcement job, had no interactions with him. First time he sees him is when he is brought to the City of Columbia Police Department after the shooting. At trial, the government elicited testimony from Investigator Fortner asking him if he made an identification based off of seeing my client at the police department. And what Investigator Fortner testified to was that he reviewed the surveillance footage after the fact and compared that to his observation of Mr. Breland, and he testified that he determined 100% that it was the same person, Mr. Breland. We have argued that is just quintessentially improper lay opinion testimony.
But why? Like what? Like help me understand. I have a little hard time understanding this argument too. I agree. Maybe it's better than McIntyre, but why is that improper? I mean, is it because he's the case agent, right? Because if imagine instead we had a jail guard who spent 6 months supervising your client, and so knew him well as a result, and then sort of they showed the supervisor the video, and he's like, listen, I've been with this guy for 6 months. I know, like, that's the guy. That would plainly be appropriate, right? There's no requirement that your knowledge of or experience with the defendant here, the person being identified, has to have occurred before the event in question, right?
I think that's correct. I have not seen any cases that have said anything.
It just logically has to be true, right? So is it the fact, so I have a little hard time understanding what it is about Fortner is like actually a problem to you, that like, is it that he didn't have sufficient time to observe your client? Like that seems to go to the weight of the evidence, not its admissibility. I guess I'm just a little, I understand you say it's
Sure.
classically prohibited.
Sure.
But what I don't understand is why.
what we've argued in the brief and argued in the district court is that essentially the identification in this circumstance, and I'll grant you that there are circumstances with jail guards, people that have some experience, exposure, even after an incident that certainly would be debatable. I mean, a defense
Yeah.
lawyer is going to
I
argue
understand.
that, but I think this falls in the camp of lay opinion testimony that is sometimes offered by the government, where the law enforcement officer or any witness, I don't think the fact that he is a law enforcement officer is necessarily the divining fact.
Okay.
What the cases say, though, is where a law enforcement officer relies on information gathered in an investigation and then offers a lay opinion based upon or about someone's involvement for the crime.
So that's totally true when it's not an identification, right? So I get those cases, right, where, people use lay opinion to sort of smuggle in like gang expert testimony. I totally get those cases. I did this enough to sort of recognize those. I've never seen those applied in the context of identification. And in fact, like almost always, the case agent just stands up and is like, do you know Joe Smith? And yes, who is it? It's the defendant that's sitting right by counsel. I mean, that happens in most every case that we see. And that's because like they are identifying the defendant as being the defendant. And so that seems like that happens all the time. I've never really heard the argument that that's impermissible lay testimony. And I'm struggling a little bit to understand in the context of an identification why that's a problem.
So I agree that the example that you just gave happens in virtually every trial with both witnesses and law enforcement.
Yep.
Identify the defendant sitting at. What we have here, and this is why I think that the fact that he's a law enforcement officer makes it far worse. What we have here is an identification of a person in a photograph from a surveillance video about which Investigator Fortner has no independent knowledge, no personal knowledge that doesn't arise from just his observations of the video, which is the same thing in a jury.
But he has personal knowledge of who's standing before him in the police station.
He certainly is told that is a client's name. He has no personal, no.
So imagine I've changed the facts a little bit and your client comes into the police station that day looking like he looks in the video. And then by the time we get to trial, your client has shaved his head and lost 50 pounds, right? I don't know anything about your client, but imagine that scenario happens, right? We would, of course, say that the officer could testify. I know he looks like a little skinny bald guy now, but back in the day, he had an afro and he was like overweight, and that's him in the video, right? So the big guy with the afro is the guy. We plainly would allow that, wouldn't we?
I agree, and I think that.
So why isn't that also true when we've got a low-quality video, right? So a low-quality video, to me, sort of feels a little bit like the same story, right? That like, your guy comes in, you probably had him in a sweater vest and glasses, right? He wasn't in a sweater and vest and glasses before. Like, this is like exactly the type of helpful testimony that we should like absolutely permit.
And if I can cabin my prior answer, because I want to be very precise about this. I think that the permissible testimony from an officer would be that my client came to the police department and looked in this manner. These are the characteristics he had. I think that testimony is perfectly proper.
But couldn't identify him in the video. Couldn't be like, listen, I saw him before he lost 50 pounds and shaved his head, right? I saw him, and so I had interactions with him, personal interactions, in person. And so I know what he looks like, and I know his mannerisms and the way he walks and those things, and I looked at the video, and that's the same person. You think he can't do that when he shows up 50 pounds lighter with a shaved head?
I think that is a far closer case and would be a worse case for the defendant. And I think that falls in line with some of the.
Why is that different at all?
Yep.
Because it's just testimony. What prompts the testimony, you're saying, it's unnecessary in your case, but it was necessary where the defendant lost 50 pounds and wears glasses. In other words, it's not a necessity question. It's a question of whether it's legitimate.
So I think why it becomes permissible lay opinion testimony in that example is the opinion identifying someone it derives from the officer's personal knowledge observing the victim on that day.
Yeah, but this is a little backwards. He observes him in the police station. And the person in the police station is the defendant in the case. And so he's basically saying, I saw the person in the police station at that time, and it's the same person I see in the video.
Correct, and I think that where that also fails in the 701 analysis is that at the end of the day, what that would permit, and this is a little bit of a slippery slope argument, I realize, but, and of course it's going to be subject to 403 and other limitations that district courts would, no doubt, but it would permit the government, or frankly, a defendant, to just put witnesses up and bolster their arguments through the 701 pathway.
Can I
don't
ask
think-
one question before you sit down?
Sure.
So this NIBIN report, can you help me understand what you were introducing it for? What was the purpose for its introduction during the government's case in chief?
Sure.
Or in your case in chief?
Sure. So what the NIBIN report showed is that it showed that there was a presumptive match. They ran the shell casings from this shooting through City of Columbia.
Yeah, no, I know what an NIBIN report is. What I'm trying to figure is, in the context of this case,
Sure.
what was the purpose for introducing this sort of presumptive, and, you know, the presumptive match, we all know, is like not very useful. They tell you can't use it, it's not evidence, all those sorts of things. But even put that aside, like what was the purpose for it?
Sure. And I see I'm out of time. If I could briefly respond, and I'll
Please, I'm sure Judge Niemeyer will let you
elaborate
answer.
on rebuttal. I think the primary purpose of it is to call into question the thoroughness of the investigation. And
That's what I thought, and that makes total sense. I understand that argument. I was just trying to figure out if there was some other thing that we were doing.
there's not, I mean, there is kind of a part two to that answer, which is
Okay.
more of a contingent part two. And I think it'll help to contextualize this. There's some argument in trial about alternative perpetrator, third-party guilt. That was raised to the district judge. I raised that to the district judge prior to trial because we didn't know how this was going to play out. This evidence was disclosed right before trial. Subpoena came in right before trial. So the direct answer to your question is to call into doubt the thoroughness of the investigation. The part two is going into trial, potentially, to link the Lexington County documents through that and potentially explore a
It was
third party.
irrelevant
we know
for this
that-
trial. I was just going to say it's irrelevant for this trial because the charge was just ammunition, and ammunition was found at the scene. The gun was found 10 months later, and the course of the gun's travel from any point in time over 10 months in this kind of market is, you don't know where it went and how it went. But it seemed to me you gained almost nothing by it unless you could place the guy 10 months later at the scene or establish that he owned it at that time. And none of that was proffered or suggested.
So I have two responses on the two different themes for trial. I think it's very relevant for the thoroughness of the investigation. That's always at issue in any case. I do agree that there would have to be some foundation laid, some links. There would have to be a nexus between the potential alternative perpetrator and this crime. And certainly there's a 10-month gap. Judge Anderson indicated he was inclined to allow this evidence, but it certainly would have been a discretionary call had we gone there. I do ultimately think that issues like the length of time would ultimately go to the weight of the evidence. But I do think that for the issue of the thoroughness of the investigation, I think it's squarely relevant. Thank you.
Ms. Hoffman?
Excuse me, I'm short. Good morning, Your Honor. Andrea Hoffman on behalf of the United States. Going directly to the leg testimony issue. With respect to Officer Fortner, it is, I think, critical that he witnessed this defendant the day after, frankly, merely hours after this incident happened. And when the discussions came up in the pretrial context of whether the still photograph from the CBP videos would be allowed.
I'll tell you my question on this, second one, and I understand the discussion we just had, but it seems to me that one of the issues is whether the defendant was the person shown in the video. The person, and in this case, the officer was looking at the defendant and say, that's the person in the video. The question I would have is, why isn't that for the jury, and why does the person have any superior position to make that judgment call and suggest to the jury that they have to listen to him?
That cycles back, Your Honor, to what I was about to explain to you or remind the court about is when the district court was allowing the still photograph to come in from the CBP videos, it did so because the defendant's appearance has changed. He had a very distinctive hairdo in the videos that he no longer has. And the still photographs show that distinctive hairdo that Officer Fortner personally observed. So one of the characteristics that can change from the day of trial.
So your suggestion is appropriate in this circumstance to fit the circumstances about which we discussed earlier here.
I am, Your Honor, because the trial of this case happened 3.5 or so
I mean,
years.
Judge Richardson's hypothetical about where the man lost 50 pounds.
I am, Your Honor. It wasn't all those factors, but it was that analogy. That hypothetical is directly on point from the discussion of whether still photographs would come in. And they limited.
This fits in the sort of rule because it has to be helpful to the jury.
Exactly.
Right? We don't let lay testimony if it's not helpful to the jury, so the trial judge makes a decision based on looking at the defendant and the video and everything. Is it helpful to the jury or not? And that's the sort of discretionary decision that we're really reviewing at its core.
Exactly, Your Honor. And this court weighed this issue, had a lengthy hearing about which pieces of still photographs, and held things out because it felt some of them would be prejudicial. So it made a reasoned and balanced judgment call that in the context of this case, given the changes, that it would be appropriate. And it is, as Judge Richardson said better than I did in my brief, it's classic identification testimony, Your Honors.
Well, didn't the jury see this video?
The jury saw both videos, Your Honor. There's actually 2 videos, but 2.
I mean, that's pretty damning evidence, isn't it? They got to look at it.
It is, Your Honor, and particularly when you're watching somebody shoot somebody 9 times, even after they fall into the ground. It was a pretty strong set of video. The identity issue specifically is being contested by this defendant, and so the opportunity to amplify that the changes in the person that's present versus the person who's in the video was useful to the government's burden of proof.
Well, on another matter, does the withdrawal of evidence at trial mean that the issue is not preserved?
It depends on the context of the issue, Your Honor.
Well, in this case.
Yes, and I hope my 28J letter made clear my less than clear presentation in the brief. The government's arguing that the defendant has waived with respect to authentication. I'm assuming we're moving to the authentication issue. That the defendant has waived any of the 9025 arguments for authentication because the only place that argument was raised was through the order of proof. And that order of proof was withdrawn before the court could rule on it. So before these, and the Lexington County documents specifically, exempting the NIBIN report for a moment, I hope that's how we say it, but exempting the NIBIN report for a moment, the Lexington County documents were never presented to a witness, were never questioned to a witness. So those documents only had any play in the trial through the order of proof, and the defendant withdrew it. To the extent that the defendant has preserved arguments with respect to the NIBIN report, which he absolutely has, he hasn't preserved them as to 9025 because that too was an argument made only in the order of proof and withdrawn before the court could rule. Now, as to the 9014 unique and distinct characteristics, that's absolutely preserved, Your Honor. So that's what I mean by, yes, it can be on the, depending on the circumstances.
I don't know what happened, but did the defendant put up any evidence when he had an opportunity to? And if he didn't, did he get the last argument?
The defendant put in no evidence, Your Honor, and the government contemplated the question of whether we should waive, because we have to remember that this whole authentication issue is in the context of a new trial motion, not just a challenge to an evidentiary ruling, but in the context of a new trial motion.
Well, but my point is, if he didn't offer any evidence.
He did not.
And it's been a long time since I practiced criminal law in South Carolina, but I understand if he doesn't, the defendant gets the last argument. Is that still true?
Only in state court, I think is what your answer is. In federal court, that doesn't work. The government retains the last argument,
It's the same.
whether they put on a case or not.
I said it's been a long time.
Thank you, Your Honor. I'm not licensed
Nope.
in South Carolina for all that I'm a federal prosecutor there. I
I
apologize.
said it's been a long time, so I'm just.
I was about to.
It is
flare.
true in state court, there's, at least used to be, John will be able to tell us for sure, but used to be the case that if you did not put on a case, then you got the last argument.
Got it.
In state court, but that has not been the rule in federal court.
I got you.
We did get the government did get the last argument, Your Honor, in terms of the closing argument.
Well,
So-
I was thinking of it in terms of making that withdrawal argument stronger, if that had been the case.
I
Okay.
apologize. I didn't know that context at all. So to that extent, Your Honor, focusing solely on the 901 aspect of the presentation, that's typically unique and distinctive characteristics. Well, that's typically, a particular hairdo, a particular item in a photograph, the shape of a vase, something that would make that item memorable at a later point, which is therefore giving credibility or to the reliability of the witness, of the item being what the offerer says it is. He is relying solely on a case number, which the district court judge found not to be a distinctive characteristic. Not surprisingly, it's a string of numbers. Every single case has them. Every document in every case has them. The simple typing of those numbers onto a document does not in and of itself make that document unique. It wouldn't be, it could be any other string of numbers. It could be added easily by someone fabricating it. I'm not suggesting by any means that defense counsel was fabricating an exhibit. I'm using it for the bigger context of why it wouldn't be a sufficiently unique or distinctive characteristic as Judge Anderson found it wasn't. There's nothing about this document that particularly would be unique, and the court was persuaded of that. The court held extensive argument on this.
So help me understand why, maybe this guy doesn't get there, but you got a ATF agent or Officer Schmidt who is familiar with the NIBIN system, right? This is a common tool that law enforcement uses. He's never seen this one in particular. But if he's familiar with the nature of the reports, and he can look at it and say, listen, this is what it appears to be. I've seen these reports before. This one looks like it's related to this case. Why isn't that enough for authentication, right? It might fail lots of different ways, given the nature of the NIBIN information, but why isn't that enough for authentication?
Because, Your Honor, the police reports inherently are something that's never been held to be a self-authenticating document. If the government...
It's not self-authenticating, right? We got Officer Schmidt on the stand, and Officer Schmidt says, I've never seen this document, right? But I'm familiar with NIBIN, right? I've seen a bunch of these others. He didn't say that part, but that's sort of implicit in what he's saying. This is a NIBIN report, right? That's all I know about it, but I can tell you that this is a NIBIN report. Why isn't that enough for authentication?
If I could start with one thing. He didn't actually say that, Your Honor. What he said is...
It's totally fair.
So we
Except,
don't have... that
hypothetically,
fact.
imagine he did say that.
Right. I just
And
wanted to
then-
clarify.
Yep, no, you're totally right.
Now,
It doesn't even tell you, though, where the document came from, whether it's a fabrication or not. He looks at it and he says it looks like it. Unless he can say it came from the state or it came from someplace, it's not authenticated.
and Judge Nyman's gotten to where I was going, Your Honor, which Judge Anderson said as well, which is you can't say that this document has any reliability. The producing entity, the federal government, didn't generate this, assuming it's real, the government didn't generate it, they can't speak to the character of how reliable the process is. The government can't even speak to it. If the government had been seeking to admit this evidence, they would have needed a custodian order certification. And the court specifically said its obligation is to apply the evidentiary rules even-handedly to both sides, and specifically said to the defense, you wouldn't want me doing this if it were the reverse. You wouldn't agree that the government could get this in just automatically by naming what it is and putting it in. And that was the concerns that the district court had, is that there's no, should an IBAN report in and of itself have reliability? Possibly, but not when there isn't a context for that. In this, there was no context found here under this circumstance. And the government had a right to hold the defendant to his burden of meeting the evidentiary standards, and it made that objection on that behalf. It's important to remember, this exhibit was only utilized one time. It was only utilized to ask a question that was interrupted, so we do not know what specific substantive question was coming to Officer Schmidt, that objection was upheld. It was overruled in every other context. The government, to the extent that Officer or Agent Brown was asked a question, he was allowed to answer the only question that Mr. Warren had for him. And
Could Officer, in your view, could Officer Schmidt have been asked the question, were you aware that there was another suspect who had this firearm 10 months later?
I don't think he could have been asked that question necessarily.
Why not?
I think he could have been asked, were you aware that the firearm, because the NIBRD report doesn't support that question, that statement, Your Honor. What he can ask him is—
It provides a good faith basis for it, doesn't it?
Not necessarily, Your Honor, because Mr. Breland was still out on release at that time. So it could have been Mr. Breland, figuratively. I mean, again, talking in hypothetical contexts. So could you have asked, were you aware that the weapon had been seized? Absolutely. You could have asked that question. He chose not to. Speaking to the thoroughness of the investigation, the theory for what this report was intended for, he did ask Agent Fortner, or Officer Fortner, about whether any fingerprint analysis had been done, whether there'd been any saliva tests done, whether there'd been any blood sample testing done, whether there'd been any gunshot residue testing done, whether there'd been any search warrants made for the car or the home or the jacket related to Mr. Breland. And all of those questions drew answers of no. So the thoroughness of the investigation was more than amply examined. Holding out this one piece of evidence, even if this court should get to a point of viewing it as an error, was clearly harmless error in the weight of the evidence. 2 videos that show this defendant following this victim through the door, back again, through the door again, and shooting him 9 times on the ground. The court properly held it out, and if by any slim chance it made a mistake, it would have been a harmless error. Is there anything else I could answer for the court?
Thank you.
Thank you very much.
Mr. Warren.
A few quick points. Judge Richardson, on your question of can that question be asked? And this, I don't have the page citation, but the government makes this argument really in response to the new trial motion that lawyers can't ask a question where the answer is going to be no. A defense lawyer, do you know about this? And the answer is no. That doesn't make it an impermissible question. It may not help on authentication.
What you can't do is suggest an answer in your cross-examination where you know the suggestion is not supported.
Of course.
Yeah.
Of course.
That's the standard.
Yeah, I mean, if you knew that he didn't know the fact, right? I mean, I assume since you were asking him if he'd seen the report, you didn't know whether he had seen the report, right? Like, have you seen this report? No. I assume when you asked that question, you didn't know the answer to it, right? And so I assume you didn't know what information he had about this Lexington County report. None of this makes a whole lot of a difference here. But the point is, you could have explored the idea of a lack of a thorough investigation without introducing the document.
I agree, and I think the question I asked, I have to go back and look, but was, did he know anything at all about the gun being seized from Lexington County? So I agree. I mean, there was certainly, we did that at trial, and
Actually, you probably could have asked directly, did you get an IBAN report? Did you request an IBAN report?
I agree that that question could have been asked, and that was the initial point I wanted to make, was that we can ask questions like that, as long as we have a good faith basis. In terms of the NIBIN report only being used once in relation to Investigator Schmidt, I just want to be very precise. The purpose of the offer of proof, and I think it says it in the introductory paragraph to the offer of proof, was to offer that document, which was among the Lexington County documents, for cross-examination of Investigator Fortner and any other City of Columbia officers that testified. Judge Anderson, I think, was well aware that we were trying to use that document throughout, and that's why we submitted the written offer of proof. In terms of the waiver argument, I think the government just gets the waiver argument wrong. And point first to a couple of pages in the joint appendix that I think help clarify this. The offer of proof is filed the morning of the second day of trials, still in the government's case in chief. And the government has cabined their waiver argument only to relate to the 902 arguments related to the Lexington County documents, which was in the offer of proof. That offer of proof is filed as a court's exhibit the morning of the second day of trial. On page 287 to 289, there's the first discussion about the offer of proof. Then on 302 to 307, Judge Anderson addresses the self-authentication arguments. And then later, 335, Judge Anderson notes that he previously sustained the government's objection to the offer of proof. It was marked as a court's exhibit. With the exception of Judge Anderson's remark on page 335, which harkens back to what he did previously, all of that occurred prior to Investigator Fortner testifying. Regardless of whether or not the documents were self-authenticating under Rule 9025, the error that we have argued in the brief is the exclusion of those documents in the government's case in chief in relation to cross-examination. The fact that Mr. Breland did not introduce those documents in a case in chief.
How do you cross-examine a witness with a document that's not admissible? I mean, it's fundamental that a document has to be authenticated. In court, you have to know that that is the document and it's not a fabrication or something else. And so somebody has to authenticate it. Now, that's not a high bar, but still, it has to be done. I mean,
Sure.
And the fact that it's in the government file doesn't mean a thing. I mean, there's could be, government picks up phony passports and picks up phony IDs and picks up notes that are all kinds of documents that can't be put into evidence, at least for the truth of the matter.
And Judge Niemeyer, the reason that I was going through those JA pages was solely related to the waiver argument. The waiver argument as to our self-authentication.
Well, what did you waive when you withdrew the order of proof?
The offer of proof was withdrawn after the close of the government's case. And that withdrawal was Mr. Breland withdrawing his effort to introduce that in his case in chief, which we ultimately ended up not putting up. The arguments related to 9025 happened in the government's case in chief. Prior to Investigator Fortner's testimony, Judge Anderson ruled that the document was not self-authenticating before Investigator Fortner's testimony. What happened in the defendant's case in chief, whether we introduced evidence, has no bearing on that error which occurred in the government's case in chief.
All right.
Unless there are any further questions, we'll rest on the remaining issues.
Thank you. Mr. Warren, I observe you were court appointed, is that right?
Yes, Your Honor.
Yeah, I want to share the same view. It's, that really is an important function of our court, and I really appreciate your service to the court.
Thank you, Judge.
Thank you very much. We'll come down and, do you want a break? No, you need a break? Okay. We'll come down and greet counsel and proceed on to the last case. right, be seated. All right, the next case we'll hear is Wells versus Johnson. And I guess, Ms. Martin, is that, we'll hear from you first?
Ms. Melcote.
Okay. Who's going to present her? You're the student counsel? All right, why don't you come forward? And I very much appreciate having you. I need to explain that you're a student that has probably done more preparation on this case than any lawyer would have done, so we're looking forward to your argument.
Thank you, Judge Niemeyer. Good morning, Your Honors, and may it please the Court. My name is Meghna Melcote with Duke Law School's First Amendment Clinic, representing appellant Mr. Wells. I'm joined with my co-counsel Jeffrey Ward with Nelson Mullins, who will be delivering the rebuttal in this case. The North Carolina Supreme Court has held that when a criminal conviction in state district court is appealed for trial de novo, it, and I quote, cannot be used for any purpose. Any purpose means any purpose. At its core, this appeal is about North Carolina's collateral estoppel doctrine, specifically what constitutes a final judgment that later subsequently bars completely a 1983 claim. An appealed district court conviction awaiting a trial de novo is not a final judgment under North Carolina law. As the court below noted, Mr. Wells has not been convicted of any crime yet, and therefore that conviction cannot bar his later claim.
Well, let me ask you this. Where are the parameters as to that nothing can be used rule? For example, suppose your client got on the stand in that misdemeanor trial and testified, and then later there's an appeal to go to the Superior Court. He gets on the stand and he testifies opposite what? Do you contend that that rule means that he cannot be impeached for giving inconsistent statements?
No, Your Honor, we do not contend that, and in that case, it wouldn't be the conviction or any findings that are used later. Rather, it's his testimony under oath that would be used later, in the same way that any interim disposition under oath could be used in the same way.
Yeah, along that same line then, it seems to me, rather than looking as to whether the judgment is final, the question is whether there was a finding by a judicial officer that there was probable cause. And the misdemeanor court found guilt and therefore necessarily probable cause, right?
Yes, Your Honor, in that finding.
Okay, so that became a judgment and that's vacated. The question is, can that be used later, that finding, can that, of a magistrate judge or a district judge or whatever, a state district judge, be used? And we found, what, 4 or 5 North Carolina cases that are after your cases that suggest that it can be used.
Right, Your Honor. So I believe you're referring to Myrick and Simpson below, relying on more. So those cases stand for the proposition that a probable cause determination can conclusively bar a subsequent 1983 claim, even when the later trial or the district court conviction is vacated in Superior Court. A couple of reasons why we don't think that that's controlling in this case. The first is that, as this court acknowledged in Gilliam, there's quite a bit of tension in North Carolina law.
There's tension in all of this because the judges make broad statements to support what they're doing. But the more recent statements, and we have our own jurisprudence that says when we're looking at state law, if we have a string of 4 or 5 cases that rule one way, and they're the most recent ones, we would tend to follow those. And I must say, this area is a little messy. There's no question about it. But I understand that under the dual state system, the slate's clean and you start over again. That's really to protect the Sixth Amendment right for a jury trial. You don't want to have a lower court making factual findings that are binding on the next level court where the jury trial's tried. I think many states have that. But that doesn't mean that, and it seems like North Carolina says that if a misdemeanor court makes a finding that's inherently finds probable cause that the crime was committed, even though there's a later trial for that, that finding can undermine a Section 1983 case, can't it?
Yes, Your Honor. So to address Your Honor's, I think, discomfort with this area of those intermediate court of appeals cases, we'd like to take note that those are intermediate cases, and we believe that they're, contradicted by the state's highest court ruling. But even on that ground, those cases are an opposite to what we're here for today. In all of those cases, we actually had a final judgment. In all of those cases, the Superior Court trial was held. In this case, Mr. Wells hasn't even gotten his day in court, and that matters. As this court noted in Gilliam.
Sure, he's gotten his day in court. He's on the second tier. He's in the Superior Court now, right?
Yes, he's getting his do-over, Your Honor. A second
Yeah,
trial,
that's
second half of a
do-over. Well,
bifurcated trial.
But he's already been found guilty once. When he appeals that, that's wiped out, and they do it again. But in wiping that out, there's still a reality left that he was convicted and that a judicial officer found there's probable cause he committed a crime. Now he's coming in and suing and saying there was no probable cause.
Yes, Your Honor. Our argument is that there was no probable cause to arrest him, and this kind of goes to the structure of the two-tier system. Part of the reason we have this is so defendants can use it as a discovery device in order to hear arguments.
Well,
and
that's
then
a pragmatic approach. I'm from Maryland, and we have it in Maryland, and I was part of that for a long time, and I know all the motives and all the reasons, but the legislatures, in having the two systems, they get rid of a lot of cases in the misdemeanor court, and but they have to preserve the jury trial right. And so that if a person wants a jury trial afterwards, he can appeal and get a jury trial, and starts with a clean slate.
Yes, Your Honor. So to distinguish those North Carolina cases, I'll try this too. Mr. Wells is entitled to a new hearing on the issue of probable cause in Superior Court. There were no hearings like that in Myrick or in Simpson or in those North Carolina cases. And the reason that those cases could be decided there is because we had full records. We know the kinds of things that were argued in Superior Court.
Can I change tax? Have you taken federal courts yet?
Yes, Your Honor.
Did you take it from Ernie Young?
Yes, Your Honor.
Good for you, because we got an exam for you. All right, so this case was removed under 1441, but it's got to have jurisdiction in federal court, and I'll posit on the front end is I don't think we have jurisdiction here, but I want you to try to help me with that just a little bit. The remedy that your client sought is a declaration, and the question I've got is how would a declaration redress any injury here, right? So the injury was the arrest, right? I totally get that, and I can totally understand how damages might redress an arrest injury. But what I'm having a real trouble figuring out is with this sort of retrospective arrest, how a declaration would redress that injury in any way.
Yes, Your Honor. A declaration would allow Mr. Wells to have his rights vindicated on the fact that he was arrested, maybe for later
And what do you
trial.
mean by that? His rights vindicated? Is that he's going to feel good about it? He's going to be able to put it on the wall?
No, Your Honor. I mean, I'm sure he would feel good on that front, but
we understand that that's not enough
Right.
to be redressed, right? So the fact that you get to win, right, isn't sufficient.
Yes, Your
right?
Honor.
That Holland tells us that just feeling good about this, in essence, isn't enough, right? Just a vindication in the abstract isn't enough, because if that was true, you could get an advisory opinion on everything, right? So, all right, so let's assume for a minute that him being excited about vindication doesn't get us there. Is there anywhere else that I should look to try to find redress based on your view? And I'll posit here that I hope my colleagues are going to give you a chance to address this in writing after we finish argument. And so you should not feel like you've got to come up with it, but since I think so much of Professor Young, I feel comfortable asking you, how would it redress it if it's not just feeling good?
yes, Your Honor. We also asked for injunctive relief on this issue, declaratory relief and injunctive relief.
So I don't
even
think,
worse.
I don't think so. So tell me where in the complaint and that we find injunctive relief?
So
Because when I'm at JA 640, oh, I'm sorry, not the right page. JA 29, it seems to only ask for a declaration.
Oh, yes, Your Honor. I believe that we had at least mentioned declaratory and injunctive relief later on in our brief, and we could also file a 28J motion on that issue. But in
Well,
terms of
but
the
let's assume for a minute that you can't add a request for an injunctive relief, which, by the way, you probably can't get, so it probably doesn't help you, but we're sort of limited to the complaint and the relief sought there. And so we could talk about injunctions for a while, but come back to me assume for a minute that the complaint only sought declaratory relief. Is there anywhere else you want me to look to think about why a declaration that the sheriff, violated your client's rights would redress his injury in any way?
Yes, Your Honor. First of all, it would provide law of the case that could help in later federal cases. Well, we acknowledge we would not want to intervene with any pending state court criminal convictions.
Okay, so maybe there'd be a later case that's filed, right, against the sheriff. But do we have any examples where we've said redress is solely dependent upon the ability for that case to affect a case that's not yet filed, that doesn't exist, that we don't know about? I mean, that seems rather speculative at best.
No, Your Honor, right, Your Honor, but the point of, I think the point of declaratory relief being available is to declare the rights and obligations of the parties in expecting any kind of further litigation to be pursued. So to the extent that there
But
may
if
not.
that's the only standard, any member of the public can file a declaratory judgment action, if that's the only interest.
Yes, Your Honor,
In other
if they
words,
have.
Without injury, the question is, why does a plaintiff have standing seeking only declaratory judgment relief?
Mr. Wells, we believe absolutely does have injury in terms of the retaliatory arrest. That is his injury. And in terms of the concern that anyone could file for this sort of relief.
Where's that alleged?
In our complaints, I believe in pages JA 22, paragraph 50, that's where we make our argument that he was arrested without probable cause. That's the injury we're alleging here. And in terms of the declaration, it's a declaration that he was in fact injured. And we take the court's concern about advisory opinions, but this is limited to the facts of this case and the obligations of the parties and of what happened to Mr. Wells.
What I want to know is, what business is it of the federal courts to go into North Carolina and interfere with their procedure, which allowed the first proceeding, which is basically a discovery proceeding. He has a right to appeal and a jury trial right. What business is of the federal court going in there interfering with that process?
Yes, Your Honor. So 2 points on that. First, this was originally filed in state court, and it was removed by the government to federal court. But to the interfering in proceedings, we actually think that our position is that a stay would be well advised here so that there would not be any interference. That's what happened in Nelson against Rockingham County when the Middle District was faced with a situation pretty much exactly like this.
But if he has his right, he exercises it to go to the Superior Court for a jury trial, isn't the issue of probable cause, doesn't the issue of probable cause have to be litigated in the Superior Court?
Yes, Your Honor, and we think it absolutely will be. We believe there will be.
What are you getting here?
Your Honor, we're getting a declaratory relief, and Mr. Wells is still allowed to file a lawsuit saying his rights are violated. It's a civil action entirely separate.
If he had standing for that, and we gave you a declaratory relief, it seems to me the neighbor could ask for that too, declaratory relief, and it would be binding. It would be binding on the parties, right?
The neighbor did not.
No, let's stick with the plaintiff here. If we issued declaratory relief, that would be binding on the plaintiff, right?
Yes, Your Honor, and on Sheriff Johnson.
Yeah. What if we said?
Why would it be binding?
In relation to the plaintiff, just as his role as a defendant in this
Binding
case.
in the criminal case?
No, Your Honor, in any future
of course
civil
not.
litigation.
That's what I was-
Absolutely
Well,
not.
how would it be? What happens in the criminal case if we issued a ruling in your favor?
Your Honor, in the criminal case, a ruling in our favor would allow the Superior Court trial to be finished and to actually get a final judgment. So we're not asking this court to decide this case of merits in any way.
What if they convict him?
If they convict him, Your Honor, we believe that there would be probable cause to arrest him, and our claim would be dismissed on that grounds, but he hasn't even had that opportunity yet.
I guess I'm trying to follow up on Judge Floyd's question. It seems to me we're sort of collateral interference here.
Yes, Your Honor, we understand this court's reticence to, get involved in issues of state law, especially a complicated area like this one,
And
but
especially when the state law, the case is not even resolved.
yes, Your Honor, but this court does not even have to do that. And the reason this court does not have to do that is because we're not even in the world of Myrick and Simpson and Moore, and that we don't even have a judgment in Superior Court. We don't know what will happen, and it is our contention that something is going to happen in Superior Court that didn't in those cases, namely a probable cause determination that would supplant the one in the district court. So this court does not have to, in order to rule in our favor here, doesn't have to decide the issues of Myrick and Simpson in North Carolina state law, nor does it have to get involved in a pending criminal proceeding. And I see my time
Wait,
is...
why- So what would you have us do then?
I see my time is expired. May I answer?
You may.
We would have this case reverse the decision to dismiss the case with prejudice, and just reverse, and we think a stay is probably the correct answer, and indeed, I think at J645, the Middle District noted it was inclined to issue a stay, but a dismissal with prejudice certainly was the wrong move. It came down on an area of North Carolina law, extending Myrick and Simpson far beyond what it needed to do, to cases where it's on appeal and no Superior Court trial's been had.
But a stay for what?
In pending Superior Court proceedings, in Nelson versus Rockingham County, that's exactly the remedy that happened there.
You're asking us to stay a state Superior Court proceeding.
No, Your Honor, we are absolutely not asking that.
What are you asking?
We are asking to reverse the dismissal with prejudice for further proceedings. We think in order to avoid interfering with the state Superior Court proceedings, the right answer would be to issue a stay pending resolution.
What proceedings? What further proceedings?
A stay in the Middle District of North Carolina of the proceedings. So no dismissal with prejudice.
Well, why don't we just remand it back to state court and let the state court process take its due course?
Yes, Your Honor, we are amenable to this lawsuit being filed in state court. The problem with a dismissal with
Wait, so then why, all right, can I go back to my question? So why aren't you just agreeing with me, right, and being like, oh, absolutely, right? We totally lack federal court jurisdiction, and so the removal was improper under 1441, which means the order of the district court is vacated because the district court lacked jurisdiction, and the case should instead be remanded to the district court, to the state court in the Superior Court Division of Alamac County, right? I mean, so what I've suggested is that you lack jurisdiction in federal court, which would result that you would then have a case in state court, and you might have state court positives or negatives. I don't know, but why do you want federal jurisdiction here?
Your Honor, we did not want federal jurisdiction. We filed it in state court twice. What we're asking for here at this court is a reversal of the dismissal with prejudice because we believe that would interfere with our ability to bring this case again in state court if it were to be remanded that way. But
but you understand what I'm asking, right? Is that if you agree with me that you lack jurisdiction to seek a declaratory judgment in this setting, the result is we vacate the district court's judgment and it is remanded to the state court.
Yes, Your Honor.
Okay.
And that's exactly where we initially filed it. Our issue is with the dismissal with prejudice. That, again, becomes the law of the case. That goes far beyond what any court would have required.
Why did you bring a 1983 case before the state court case was resolved?
The reason for that is because of the statute of limitations. We would have exceeded that. Mr. Wells, is, next week actually, will have been waiting 4 years for his Superior Court trial. And now,
but the cause of action doesn't arise until you have that, right?
at the time of the injury, it's been 4 years since there. The statute of limitations is 3 years. So that's why we filed it. And again, cases like this have happened before, like in Nelson, in the Middle District, where the action was filed in between the pending district court and Superior Court trial.
Okay. Why don't we hear from who's next? Mr. Bader?
Thank you.
Okay, thank you.
Good morning, may it please the court. Stephen Bader from Cranfield, Sumner, and Raleigh, here on behalf of the Alamance County Sheriff Terry Johnson. think this panel's identified at least one of the critical issues here as it relates to state law, which is in North Carolina, a district court criminal conviction.
But before you get to North Carolina state law, you removed the case, and you asserted that we have federal jurisdiction under 1331. Can you help explain to me how a declaratory judgment with respect to a retrospective injury can possibly satisfy the redressability requirement?
I'm not certain I can, Judge Richardson. What I can say is we removed the case because there was a federal cause of action brought under 42 U.S.C. 1983.
But you understand that doesn't really help you, right?
I think
a federal cause of action doesn't give you federal jurisdiction. You got to have standing to pursue the remedy sought. And they've sought only one remedy, which is a retrospective declaratory judgment.
I think what Your Honor has done is identified something that was not flagged by the parties earlier. And so I don't know if I can stand here today and give you a satisfactory answer. Certainly, if my friend on the other side is going to submit 28J authority, I would do the same, but in the interest of being efficient here today, I'm not going to try to fumble through it. I think your point is well taken.
All right. Thank you, counsel.
Very directly to the issue and how the district court here resolved this case. You know, North Carolina law, admitting that there are some cases that have questioned how this rule came about and its wisdom, remains that these convictions have preclusive effect. And that is true even if the Superior Court later vacates the conviction, unless the plaintiff can show that the conviction was procured by fraud or other unfair means, which is not alleged in this case. I want to point something out that I don't
quite follow what you're trying to tell us. You get your bite at the apple in the district court. If you lose, you get to appeal to the Superior Court. Why just that simple? Why would you remove it to federal court when all you got to do is get the case tried in Superior Court?
Judge Floyd, so the Superior Court case is just strictly the criminal proceeding against Mr. Wells for disorderly conduct and failure to disperse. His civil lawsuit that he filed separately included those 1983 actions that from our standpoint were removable, which is how we got here.
But they didn't, as I understand, and I think Judge Richardson asked this question, they didn't ask for an injunction to stay the case or stop it.
This case?
Yes.
That's correct. There's never been a request to stay this case. And I don't have an answer as far as why Mr. Wells has taken that approach. You know, from our standpoint in looking at Myrick and then looking at Simpson, it doesn't make any difference because even in those cases, what the North Carolina Court of Appeals recognized is that the preclusive effect that's given to district court convictions still stands even if the Superior Court later vacates the conviction. But I want to point this out because I don't want this to get lost. This conviction has not been vacated. It has been stayed. And by operation of North Carolina statute, which sets forth a two-tier system, 15A-1431 parens F1 says that an appeal pursuant to this section stays the execution of all portions of the judgment. And then parens G and parens H go on to say that if the defendant does not pursue the case in Superior Court, it's remanded back to district court, and then that judgment is entered. So in that sense, Mr. Wells comes before this court and before any lower courts, I would argue, in a less strong position than the defendant in Myrick, who's actually had their conviction be vacated. His conviction still stands. It's just stayed pending final disposition in Superior Court. But ultimately, what the Myrick court recognized is that is the law in North Carolina. It considered the very argument made by Mr. Wells here, which is that the line from State versus Sparrow, that within this two-tier system, when there is an appeal to Superior Court, it results in a trial de novo, so the conviction is annulled and unavailable for any purpose. And it said that was in another context, presumably that context being a criminal sentencing issue.
Well, why don't you just file a motion in the federal district court to remand it back to the state court?
Well, I'm not prepared, I'm not sure I can give you a great answer to that, because I want to take a look at if there's something underlying here in the allegations that would support federal jurisdiction. Our view of the case was that it was.
Well, I think if you read Steel Company and a couple of other cases, if you have a basis for jurisdiction, you can remove, and Section 1983 clearly isn't.
Right.
The point that Judge Richardson makes is there's a standing issue which is also jurisdictional. Now, I'm not sure that affects removal jurisdiction, but it probably, well, it does, if there's a standing issue, does affect whether there's a case or controversy before us. And if there's not a case or controversy, then it seems to me we should just dismiss this action without prejudice because there's no redressable injury.
I appreciate, Judge Niemeyer, how you've worked through that. I
don't
can't.
know if I'm working through it. I'm raising questions because, and as Judge Richardson suggested, I'm going to ask counsel to submit a brief just on the standing issue when only a declaratory judgment is requested, a standing issue under Section 1983 for a violation of the First Amendment. And if you can both submit your memorandum within 10 days simultaneous, and I'll have the clerk take care of that. Thank you.
Appreciate it, and just to make as efficient of use of a time as I can, then, you know, from our standpoint, when you look at the case, Myrick, Simpson, relying on North Carolina substantive law, has said, even if the Superior Court conviction were vacated, there is still a preclusive effect.
What's the best case you have? Is Myrick the best?
I think Myrick's the best case. Myrick cites Moore versus Winfield, which is the 1935 Supreme Court, North Carolina Supreme Court opinion that addresses this doctrine. It discusses Sparrow and why Sparrow can't carry the weight to suggest that it would apply in a case like this. The Simpson case that followed provides the exact same analysis. The outcome is different because the plaintiff in Simpson had evidence to suggest that the conviction was procured by unfair means of fraud, which is why that case was allowed to proceed. And then Gilliam versus Seeley, which is this court's decision from 6 years ago, I would argue really doesn't have any controlling effect here, but it does flag the issue and talk about Myrick and Simpson and how those cases came down and why. That was the case where this court said that North Carolina is not going to give preclusive effect to, in that case, a 31-year-old murder conviction that had been obtained by unfair and unjust means in the form of DNA evidence that had later been discredited, which is just not what we're dealing with here.
I'm just confused about this situation. If he goes to the Superior Court and he gets an acquittal, then is not his record expunged as if you keep saying something about having something remaining in the district court. Well, what remains?
If he goes to Superior Court, under current North Carolina law, if Mr. Wells goes to Superior Court and he is acquitted, his district court conviction still has preclusive effect as to a finding of probable cause. And that preclusive effect would work to result in dismissal of, or would frustrate his 1983 claim because it's dependent upon him showing a lack of probable cause. And that's the framework that was set forth and discussed by the North Carolina Court of Appeals in Myrick. And that's where the Court of Appeals said, this is the law in North Carolina. There may be policy reasons for it to be different, but that is what the Supreme Court has announced.
If we just say we don't have jurisdiction and send the case back, I guess, without prejudice, it's back in state court. So what then?
I think at that point, it really depends on how the matter proceeds.
All right, he goes to Superior Court and he gets an acquittal.
I think he's right back where Myrick is, in the sense that Myrick says his prior district court conviction still has a preclusive effect on probable cause.
But for what purpose?
That's what North Carolina substantive law is. Now, I would agree with where
But
I
your
think-
point is only for probable cause.
Right.
Like, it wouldn't be preclusive that he was guilty.
Right.
Right? It's only preclusive with respect to probable cause, because probable cause is well short of what it required to be guilty. You can be acquitted in the Superior Court and still have there been, like, more than sufficient probable cause.
That's
That's
exactly
the
right.
theory behind the North Carolina courts.
That's exactly right. And all I would say to, I think, further address what Judge Floyd is saying is that if he was in that position, then at least he could try to advance some of the policy arguments that were made in Myrick. From our standpoint, that's just not proper here, since his conviction has never been vacated. It's just simply been stayed. So he's kind of got out in front of it and is in a position where this case is almost mounting a collateral attack against that Superior Court proceeding.
So under North Carolina law, if he dismissed his appeal to the Superior Court, he would be left with the judgment against him in the misdemeanor court.
Correct. And then this case would be heck barred, and the analysis would be
Is there,
straightforward.
so I understand the statute of limitations in the federal court, there's a 3-year statute of limitations, so they probably can't file a new federal court action. Is the state statute of limitations to sue the sheriff, has that also run given that 4 years has passed? Do you know the answer to that?
I don't know the answer to that. I hesitate to speculate. I'm not.
Yeah, no,
trying to be cute.
I don't want you to
don't know.
speculate, I was just asking if you knew.
Yep.
Why wouldn't the statute of limitations on the Section 1983 case arise when he receives a judgment in his favor? In other words, if the Superior Court were to acquit him, he then would have a Section 1983 case, and you would then have your defense under, as to the probable cause issue.
Well, Judge Niemeyer, I believe what the case law says is with these 1983 claims is that they arise with what they believe, when the constitutional violation occurs, and not necessarily when a criminal case is adjudicated down the road. And the argument here is that this First Amendment violation occurred when Mr. Wells and others were protesting at this park in Alamance County. So I think that would be
So
the.
it would,
appeal date.
his injury in theory would exist whether he's convicted or not. Even if he was.
In theory, yes.
Even if he's convicted, he could have been arrested without probable cause, because the evidence that one is convicted on is different than the evidence, in theory, that one is arrested on.
Yes, I'm not sure that's possible in this case, given the nature of the charges and his First Amendment theory, but academically, yes, the two can be separate.
Right, but we have to do, but we do the heck analysis based
Right.
not on, well, it just so happens here that the overlap in evidence sort of means the same.
Well, that's right. In this case, his argument here is that there was no probable cause to arrest him and then subsequently convict him of disorderly conduct and failure to disperse, because all he was doing was exercising First Amendment rights. If there is a criminal judgment to the contrary, then that cannot be attacked via 1983 proceeding. The only other thing I just want to touch on very quick.
Can I just ask one
please.
other question? You said something that I think maybe is different than what I understood. You said that he complained about no probable cause to arrest or to convict him. I understand the suit against the sheriff to only be the first one, no probable cause to arrest him, because a suit against the sheriff for convicting him is nonsensical, right? Because the sheriff in the state, and so it's not prosecuting, right? It's the wrong defendant.
Right. I misspoke. I think what I was trying to get out is that if he has a conviction as to the underlying charge, it's going to have a preclusive effect on the probable cause to arrest. That would be necessary.
Maybe. Why is that necessarily true?
I think it is under the facts alleged, because what he is saying is that there was no grounds for the sheriff to arrest him because he was exercising First Amendment rights and not committing disorderly conduct or failing to disperse. If there's a criminal judgment saying that by engaging in the conduct that he was engaged in, he committed the crime of disorderly conduct and the crime of failure to disperse, then the sheriff necessarily would have grounds to arrest him, and I don't believe he would be able to pursue a 1983 claim.
Because it would necessarily call into question the conviction.
Right. I think that's exactly right. Just the last thing I want to hit on, and I want to make sure I address any other questions that the panel has, is just the idea of a stay at this point. That's never been requested. I think it was suggested by my friend that the court could just go back and stay this case and let the Superior Court criminal proceeding play out. I just simply asked the court not to do that. Number one, it's not before the court. It's never been requested before. Just to specify here on the record, in docket entry 47, after this matter was fully briefed on summary judgment, the district court judge entered an order and said, I need some help, I need some clarity from the parties as to the issues, and one of the things that she intimated is she may be inclined to stay the case and ask the parties to state respective positions on it. The plaintiff at that point did not say, yes, please stay the case. What the plaintiff said in docket entry 52 is, if the defense were to get summary judgment on one of the claims, being the Neves claim that has not been raised as part of this appeal, then you should just dismiss the other summary judgment motions without prejudice, but at no point did they ever ask for a stay, and certainly from Sheriff Johnson's perspective, we have defended and advanced the case in response to the positions that they've taken. And I guess the last thing I'd add on that is the contained record before this court is not that this judgment has been vacated. Again, it's that this judgment, the criminal judgment, has been stayed. And so consistent with Myrick, which to Judge Niemeyer's point is really the best case that deals with these various issues, summary judgment would be appropriate.
All right, tell me, if we're gonna rule in your favor, what is the best ruling we can give you?
To affirm summary judgment for the reason that on the undisputed facts under North Carolina law, the criminal conviction in district court has a preclusive effect consistent with the North Carolina Supreme Court's decision in Moore versus Winfield and Myrick and the Court of Appeals decision rather in Myrick and as well as in Simpson.
All right.
Thank you very much, Your Honors.
Yeah. All right, I guess we'll hear Mr. Wald.
Good morning, or perhaps good afternoon at this point. My name is Jeffrey Wald. Just a few points in rebuttal. First, I want to directly answer Judge Richardson's question to my colleague, whether we would consent or what we thought of a remand to state district court. And my response to that we would be wholly in favor.
You don't get to consent, right? The question is, do we have jurisdiction? I wasn't asking her to consent.
Fair enough.
I just was suggesting to her that it might be a different way of getting to the same place, but whether you consent or not sort of matters not to me, I'm sad
Fair
to
enough.
say.
I'm not sure we have authority to send it back, do we? In a Section 1983 case, alleging a violation under Section 1983 is removable to federal court, isn't it?
That it is removable to federal court. However, I think the problem that Judge
Well, I
Richardson
understand
raised.
the problem. The problem is a standing question, which is also jurisdictional.
Correct.
But there is federal jurisdiction to hear a case to decide the standing issue. In other words, my point is, this is clearly a Section 1331, and I think that is removable. It's a claim under federal law.
Yes, Your Honor, it's a claim under federal
Now, whether
law.
we have
But a
jurisdiction.
district court has to remand, if it lacks federal jurisdiction under Article 3.
Right.
A removed case must be remanded to the state court, right? It's not dismissed. If a case is removed under 1441 and Article 3 jurisdiction is lacking, it is remanded, not dismissed, right?
Correct, and that is the point that I wanted to make, Judge Richardson, is that I want to be very clear that as to the statute of limitations, North Carolina General Statute 15213, it's a 3-year statute of limitations, and there's case law very clear that says the statute of limitations begins to run at the time of the wrongful arrest.
If there were no standing here, there'd be no standing in state court either, would there? It's the same problem. Standing doesn't depend on a federal or state question, does it?
No, not necessarily, Your Honor. The question could be different under the state law, and it would be up to the state courts to determine the issue at that point. Our request would be, if you're going to find a lack of standing, not to dismiss the case, because then we're going to come into a statute of limitations problem, but rather to remand or to reverse, send it back down to the district court for an instruction to remand back to the state court for lack of jurisdiction, if you are going to so find. We'll file our supplemental briefing. Frankly, this has not, the personal jurisdiction issue has not been raised, to my knowledge, below.
No, we're going to give both parties because we've explored this question here for the first time. Nobody's had a chance. We're going to give you 10 days to brief.
Thank you, Your Honor.
Yeah.
We're also going to ask you a question anyway. So why, help me understand why a declaratory judgment here? I mean, y'all filed, I don't know if this is you or not, but y'all filed for simply a declaratory judgment. And I guess I'm just having a little hard time understanding, like, why, like, what that's trying to achieve. And you can say, I just want to answer that in the briefing that the judge offered to you. But I wonder if you have an answer for why that makes sense, particularly given that the statute of limitations is now run. So it's not like you can use that declaration in a subsequent, like, federal action for damages, because the statute of limitations is run on a federal action for damages, right? Which was the suggestion your colleague
Right.
made. So I guess I'm just having more trouble understanding what the, like, plausible reason for this is.
Sure, and I guess I'll answer it in two ways. First, I'll just say that I wasn't there for the preparation of the
Right.
complaint, so I don't know the theory behind it. I will, though, then point to paragraph 65 of the complaint, and I'll quote it for your honors, which says, Mr. Wells' participation in the 11th of July 2020 demonstration was not an isolated event, and without a declaration that his arrest was improper, Mr. Wells is uncertain as to how he can exercise his constitutional rights when speaking and acting during future protests.
Right, but this is Lujan, right? So this is the problem, like, you don't get to say generally, I might one day travel to a forest somewhere and therefore worry about endangered species, right? I might one day think about protesting again and therefore I want a declaration. Like, you have to have specificity, right? You have to be like, I'm very upset about this thing that's going on and I plan to go protest at this, like, this is the Lujan problem. Like, I totally get the arguments you could make here. 65 doesn't get you there.
Right, and I think as I reviewed the complaint during the argument, this is the closest I could come up to with a more concrete future injury, and we don't make a request for money damages. So that's as much as I can say on that point. I see that my time has expired unless there are other questions.
All right, we'll adjourn court for the day. We'll come down and greet counsel and ask counsel to come up and greet Judge Floyd. And then we're going to come down to the well of the court, and we have some guests here from the class of VMI. We're going to speak with them and let them pepper us with questions if they have any, so you guys can think of some questions that may be appropriate.
Or inappropriate.
Or inappropriate. So that's what we'll do now.